ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಿಟ್ಟಿಂಗ್ ಲೇಟ್ ಇದೆಯಾ ಇವತ್ತು?
Lordship,
One mention
on the last hearing date, your Lordship was pleased to direct us to serve the notice and move the matter, your Lordship, wherein the respondent through suppression of facts has obtained a maintenance order. We have served the copy, your Lordship. If it may kindly,
No, order must be, once you file the memo, matter will be listed.
please, your
You
Lordship.
file the memo in the registry.
It's already filed, your
It will come.
The Lordship confirms, and serial number 4 in the first list may be permitted.
Out of the list mentions first.
my lord,
Matter relates to the application being rejected for production of additional documents.
When was the order?
Because the order was on 21st of January. The honorable court has stayed the matter. Now I want to finish this off. It's a matrimonial dispute. Both are senior citizens. It's for judicial separation. 2 documents have been rejected and 2 have been admitted by the court.
We'll see whenever
this
the time
respect-
whenever the time permits.
Please,
Give it.
any date convenient to my lords may be arranged.
Claimant appeal, my lord. For admission, claimant appeal, my lord.
Yeah, look at the list. Yes.
Petition is for enhancement of maintenance filed by wife. The notice was ordered last day and it is duly served. Please note it.
File the memo.
But from registry only notice has been issued.
Huh?
From this court only notice has issued and it has been served. I have verified.
Someday, take it someday.
And for respondent,
my lord, GNWC matter, my lord. Custody has been given to the husband, my lord. Children are 6 years old, my lord. Mother Kotila Swami, and no interim order has been passed.
Which year is that?
25, my lord.
Because no interim order will be passed unless until it is served on the.
It is served, my lord. As per this court's
Yes,
order, it
look
is
at
served.
it. Take that. Yes.
and for respondent, I filed an IA for withdrawal the amount deposited with appellant.
List that matter on Tuesday.
My lordship, for the petitioner, my lordship, me being a single parent, my lordship, taking care of a minor child, I am not able to bear my own cost, my lordship. Upon that, the court has ordered to bear a cost of traveling expenses of the respondent, my lordship. That order has been challenged, and the maintenance has been not been given to me, my lordship. It's kindly
Take
listed.
that.
My lordship, any date may be given, my lordship.
We'll
My
see,
humble
we'll
sir.
see.
Much obliged.
Page wise adjournment,
Yes.
1, page number 3, serial number 11, 12, page number 4, serial number 13 to 17,
Serial number 21 in this matter.
page
Serial number 12. You appear for, you are for the,
I'm for respondent, my lord. Village Swami.
I'm for the petition.
Village. Date Veda Swami. Date, 1 week time.
no 1 week, whatever matters that will be adjourned today will come in the month of October because no dates in the next couple of days. Does this matter at the request of both the parties in the month of October?
Interim order be kindly.
Yes, interim order
Serial number
granted
21.
is extended.
Serial number 21, madam. Since the settlement is going on between the
Please wait, please wait.
page number 4, serial number 13 to 17, page number 5, serial number 18 to 28,
Yes.
Serial number 20, my lord.
serial number 21.
20 next week, my lord, because I have to file memo of calculations. Serial number 20.
Whenever the matter comes up hearing, then the settlement talks will start. And after the matter is adjourned, it will stop. This matter also in the month of October.
page number 6, serial number 29, 29 and 30, 29.
My lord, serial number
Is it 2
30, my
o'clock?
lord. Lord, serial number 30, my lord. There was an in-chamber today. The child has been diagnosed with
89.
typhoid and bronchitis. my
Anyhow,
lord.
it is adjourned.
It's on 18-9, 18-9.
Much
89.
obliged, much obliged.
List number 2.
List number 2, my lord, serial number 14, the advocate on record who is
We'll call page wise. Please wait. How it is happening?
Page number 3, serial number 11.
Yes, 2. What is happening, Ms. Chantra? None of the matters are represented. I asked the insurance colleagues also. What is happening? Ms. Chantra is not coming. Anyhow, you're ready today or not? When do you want? List this matter next week. Delete the caption from dismissal. Yes, next.
Page number 3, serial number 11. Page number 4, serial number 12 to 12, 13, serial number page number 5, 14, 15.
Serial number 14, my lord, the advocate who is on,
Huh?
advocate who is suffering for the appellants, my lord, is suffering from
Inform the
my
other side.
I will inform them, I will.
That's the difficulty. No will inform.
I am
You have
not
to
the
inform
advocate
and-
on record, my lord.
Then he has to inform. No, they will come
I
and they
will-
will again,
I will inform, my lord.
we will adjourn the matter when in the presence of the other side advocate. Yes, next.
Page number 6, serial number 16 to 19. Page number 7, serial number 21 to 22. Page number 8, serial number 23 to 27.
My lord, serial number 25, my lord. K. Suresh has undergone an operation, my lord. It may kindly be called a week after next week.
Is it informed to the respondent?
My lord, I have requested by
That's what another
Suresh
matter is
colleague,
mentioned now of the same advocate. Where is that?
That is serial number 14.
29.
Then also.
It is submitted that the council has undergone. No, that is, this advocate and that advocate is different. Yes, 25, when council submits that, the counsel for the petition has undergone a surgery. This is matter in the month of November. Yes.
Okay. 29 also.
That we have to do when the matter reaches not now. Yes.
Page number 9.
29 also, my lord.
29.
Yes.
Page number 10, serial number 30 to 33.
Lordship, appearing for the
31, my lord.
31, appearing for the
But on
respondent.
record, advocate counsel is not read. Seek time.
You appear for the
I am for
respondent.
respondent.
Proxy
Also in the
counsel.
month of October. At the request of both the parties. Yes.
31.1, list number 2, 31.1, my lord.
Both will
So,
go.
okay.
Yes.
Page number 11, serial number 34 to 36. Page number 12, 7.
Yes,
List number
next.
3, page wise adjournment, serial page number 1, serial number 2, 3.
My lord, one submission, my lord, serial number 1, my lord.
One will not be adjourned. When the matter is in dismissal, it will not be. You have to wait
my
till.
lord, yesterday the matter was listed. I was held up in the next court, my lords.
That's why it
Before I
will-
came, the matter has been listed.
It
Yesterday,
lets-
my lords came.
Why it is listed is, give this, the colleague who has mentioned about this matter is that an adjournment was sought yesterday in this matter.
No,
In one matter, they mentioned adjournment was sought, and look at it. Oh, it is not that, yes. You can wait. Dismissal matters as a matter of policy and not
my
adjournment.
lords, documents I have to produce. Matter is with the parents and the student.
No, man, no documents, whatever are the documents.
Two
on there,
documents I have to produce. May kindly be taken in the next.
Page number 2, serial number 4 to 8. Page number 3, serial number 9 to 12. List number 4, referring to local address matters. Memo for
Yes,
acceptance
one memo for a memo is filed for acceptance of public paper publication in respect of R3. Memo is accepted and notice to the R3 is held sufficient. Then two,
United India Insurance Company.
it's already notices. It's there. R3 is
United India Insurance Company.
who appears for United India? You appear. You have. Mr. K. Nagaraj is directed to take notice on behalf of R3. Then comes for the appellant to serve the copy of the appeal memo. Yes, next.
Serial number 2.
Two. Who is R2?
To
Give the file. Is Nagaraj is directed to take notice. Counsel for the appellant to serve the copy. Yes, refer. These matters are referred. Yes, next. Next.
Number
3.
3.
All other matters refer to the Lok Adalat. Yes, we'll call the list.
List number 1. Part-time matter, serial number 1. VB Sitramaya, petitioner.
Appearing for
Sri
petitioner.
Prakash.
Yes. It's adjourned.
My lord, I got the instruction, but my lord, he didn't pay even single pay. in spite of, my lord, the order passed in criminal miscellaneous petition. My lord,
What was the instructions I asked you to get today?
pardon?
What was the instruction?
Lordship
Why it is done?
Your Lordship was pleased to allow their petition and set aside this impugned order.
My lord, on the ground that there is overlapping, my lord, what happened is,
Yes.
yeah,
No,
wife.
no. There are two petitions.
Yes,
When,
ma'am.
whichever you want to pursue, that you pursue. The other one I'll dismiss.
No, what happened is, my lord, I filed, my lord, wife and son, my lord. They together filed a petition 125.
I understand.
No, I understood, my lord, what is
He
supposed.
is not paying.
Yes, my lord.
That I understood.
He didn't pay a single fine. My lord, now the contention of other side is, my lord, he filed a MC petition seeking decree of my lord, restitution of conjugal rights. Petition is pending. In that I made application for a maintenance, and the court, my lord.
Then we'll do one thing.
Yes.
You pay the amount in either of it. We'll dismiss the other one, or else we'll allow this also.
This one may be allowed, my lord, in CMIS.
No. First of all, you pay.
Let him pay.
It is not a matter of course.
Yes, my lord is suffering from
Please tell your client to pay the amounts. I'll give a date. By that time, let him deposit some of the amount. Let him pay some of the amount. Then we will see. Otherwise, I'll allow both. I'll dismiss both.
Leave it to honorable. 75% disability is suffering. I think you may not be
You
able
are not.
to. Yes.
That order is already staring at you, and they have already some material to show what is your income and all.
My lord, the respondent is also having sufficient properties in Tumkur city. So valuable properties, he is having 75% is spelled down and hip has been fractured. And he is not having property, his mother is having.
You
only
yourself
house.
are saying,
Yes, please.
allow one, let them pursue one.
Sir, let
In
the
the other one, what
Sir,
is that?
my lord,
What is that? Let them file EP.
My lord,
What
see-
does it mean? When an order is passed long back, you don't respect that order. You don't obey that order, and now you tell the court that let them file EP. What does it mean?
Leave it to honorable court. My lord, that is I have already instructed him to pay the amount. But his difficulties, he says that he is not able to.
Then I'll allow both. Please come. Or you, dismiss your this thing and allow their petition. Agreed with the order passed in IA number 7 in an MC number 59 of 2020 dated 10th March 2022, whereby the court had granted maintenance of an amount of rupees 7,000 and 7,000 to
Wife and 5,000.
7,000 to the wife and 5,000 to
Son.
son. The husband is before this court. Parties are referred to as husband and wife for the sake of convenience. The wife had filed the MC. The wife had filed I number 7 seeking maintenance of an amount of rupees 15,000 for her and 10,000 to the son respectively. It is stated that she has already filed a petition under section 125 CRPC seeking maintenance in criminal miscellaneous number 107 of 2018. But the husband is dragging on the matter. Meanwhile, her father, a practicing advocate, expired on 7/12/2020. Accordingly, she has come up with this petition. The husband filed his objections, stating that he had initiated the proceedings under Section 9 of the Hindu Marriage Act seeking restitution of conjugal rights, and the wife has failed to join the husband to lead marital life. In spite of several efforts, he has to file the petition. It is his case that he is not able to eke out his livelihood and is depending on his mother. Only to harass him, the present petition is filed. The court, by order impugned, allowed the, has passed the order and observed that as per the wedding card, husband is MTech graduate,
Both of them are MTech graduate.
is employed in software company and working from home, which makes it that is gainfully employed and able to maintain the respondent and maintain the wife and son. And the interim maintenance needs to be just and reasonable. And accordingly, the court had granted the maintenance. Court also has taken note of the proceedings initiated in criminal miscellaneous 107 of 2018. But the court observed that the interim maintenance is not awarded. Next paragraph. Learned counsel appearing for the petitioner husband submits that in the miscellaneous, in criminal miscellaneous 107 of 2018, how much is granted?
So that's same, 7,500.
Even in that
And one
also.
more submission, my lord, I will advise him to comply order in one of the petitions. Let there be some observations. If he has complied in CMS, so. Yes, sir.
107 of.
I will give him
I will
strict
also, I'll fix the timeline.
Yes, I will give him strict instructions.
107 of 2018. But the interim maintenance is not, what is that? No, criminal miscellaneous already 5,000 and 7,000 is already granted. There cannot be, and further is 70, there cannot be two maintenance simultaneously. At that point of time, court had granted the maintenance as in the criminal miscellaneous orders are not passed. It is submitted that the counsel has already advised the client to pay the maintenance
In any one of the cases.
in any one of the cases. Next para. When counsel appearing for the respondent submits that in criminal miscellaneous, an order was passed on
Not in 2022, madam.
2022 till now. No amount is paid by the husband. This particular aspect is not denied by the land counsel appearing for the husband. It is submitted that the wife has to maintain herself. The husband is, apart from being an MTech graduate, is also having valuable properties, and there cannot be any difficulty for him to pay the amounts. What is the other one? That is arising out of the same, you are seeking enhancement. 2503. It is nothing to do with this.
No.
So, how the land counsel for the petition and land counsel for the.
One more submission, my lord, is disability up to 75%.
Is having a disability of
Can kindly be considered.
But the land counsels on either side peruse the material on record. The main contention of the land counsel for the petitioner husband is there are two maintenance in two proceedings, maintenance is awarded, that is 5,000 and 3,000.
So,
On a query from the court whether any amount is paid in either of the proceedings, it is submitted that he has not paid the paid the maintenance in any of these proceedings. When an order is passed by the court in the criminal miscellaneous, when that is not questioned by the petitioner or questioned by the husband, he cannot afford to disobey the orders of the court and come before this court and submit that already in criminal miscellaneous an order is passed. This court is also conscious of the fact that he is suffering with 70% of disability. Hence, this court is passing the following order. If the petitioner pays the entire arrears within a period of 2 months from the date of receipt of the order in criminal miscellaneous number
107 of
107 of 2018, then the order, and he need not pay the maintenance as per the impugned order dated so and so. If the maintenance is not, the arrears of the maintenance are not paid in criminal miscellaneous, he has to pay the maintenance even in these proceedings. Accordingly, the petition is disposed of.
Till number 2.
Some time limit, my lord.
2 months.
Okay. Like,
Karaj DS for petitioner, Jairaj DS for respondent.
Respondent wife. This matter, my lordship, the petition husband has challenged the order of granting of the litigation cost instead of one time, it is
This
granted
what
as
you
per
say,
month.
how can there be a litigation
That's,
cost
your
of every
lordships may
month?
kindly see the impugned order. It's not only for legal expenses, it says other expenses. And moreover, my lords, in the
What is granted? What is the
In
amount?
page number
15,000 is granted.
Let's see, page number.
64, my lordship.
64 is the operative portion. 63, the lordships may kindly see page 60.
Finance in the, where brought that, so 15,000 to the respondent, to the legal and other expenses.
Other expenses.
What is the amount that is sought for?
She had charged for 25,000 rupees
What is
for
your
litigation
salary?
cost only, not any other expenses.
Kindly see, my lords, my
No,
application.
let's see your application.
Yes.
Court cannot give something beyond your, the counsel for the respondent has filed the above said IA seeking to direct the petitioner to pay sum of rupees 25,000 towards legal, no, other expenses also.
That's right.
Other expenses also there, but kindly see that first line of the in page number 64. First line of the page number 64. The respondent is not claiming any maintenance.
No, the order itself speaks.
Let's see your application.
Please,
IA, where is IA?
please.
Page number.
Lords, your lordships may kindly see my application. At page number 52, for the reasons stated in the accompanying affidavit of respondent, it is respectfully prayed that this honorable court may kindly be pleased
In the
to,
affidavit, let's see.
please. Para 6, your lordships may kindly see.
Para number 2 of the affidavit.
No, para 6, I'll come.
6.
Please.
He
Because
has
I
stated about that.
have, with your lordship's permission, I have one more submissions to make.
Please.
My lords, I have preferred criminal miscellaneous in 150 of 2020-22. My lords, your lordships may kindly see annexure E, operative portion at page number 49, where the honorable court has granted only 8,000 payable by the husband to the wife. It's not paid
Not to
a
the wife,
single
not to the wife,
penny.
only to
He
the
has
daughter.
challenged the order. He has challenged the order. It has been confirmed. Even as of today, he has not paid a single penny.
No. What is his income?
My lords, his income as per the records he has produced as on 2020-22 is 35,000.
No, 35,000.
Please.
No, 15,000 in one proceedings, 8,000 in one proceedings. How much it becomes?
23,000.
So
Please.
35,000 is the income and 23,000 he'll pay towards maintenance. How
No,
is it
but my
right?
grievance is not even complying with the order of the court.
Whatever it is. No, you can't have.
She is working, my lordship. She is working as a
Can I-
lecturer.
No, even the petitioner is working.
We can grant another 2,500 in this.
I'm sorry.
And another 2,500, income of 35,000. If there cannot be, you can't give more 75%, 80% of the income as maintenance. That's not the law.
My lords,
Maximum 30% of his salary
That's
would be 10,500.
no, now he is getting 50,000.
Where is
Lords,
that?
as on 2022, it was 35,000.
But the order is passed in 2020.
23.
Then he was getting that amount.
And I have one other submission is, my lords, this is a restitution petition. He's not, my lords, made any effort to seek any custody towards the child.
That we
I
will
wanted
not
to bring
go
it to your
into all
lordship's
those
notice.
aspects. We are only concerned with the maintenance. And there cannot be 23,000 from the fact that he is earning 35,000.
Please. I understand what your lordships are saying. My only grievance is I have to maintain my child. I've rented a house. I'm
What is
situated.
your salary?
Lords, my salary is 35,000.
Then,
No, that is
then
why I'm
he's,
not.
now you, now this court will, is directing the husband to pay like, if we take it as 11,000,
Please.
that is 8,000 in that and another 3,000 in that. So it is, the requirement of the child is taken care of.
Just may push it to Malaj. I won't make much submission. 5,000 your lordships may consider because she's still a
How much it
minor.
will become? 8 plus 5, 13,000.
That's
Like in that matter, my lordship,
It's only 5,000 in this. I think you shouldn't argue on this.
I will leave to lordship.
15,000 to 10,000. Yes, please
reduction of
come.
10,000.
15,000 rupees, she is working, my lordship, she is staying.
What about the child? Who will take care of him?
Even,
Is it not your responsibility? You are not giving to the wife.
even
Please
we will
come.
take care of that.
Agreed with the orders passed in.
Other expenses means, my lordship, she is.
I will clarify that. Agreed with the order passed in. What are the IA?
IA number under
24.
section 24.
There is no IA number.
IA number 1.
Agreed with the orders passed in IA 1. In
MC 69 of 21.
no, where is that order?
Page 61.
Agreed with the orders passed in IA number 1. In MC number
69 of 21.
59 of
21.
21, whereby the court had granted 15,000 as towards legal expenses and other expenses dated 4/1/2022. The
20.
husband is before this court. Then counsel appearing for the husband submits that if it is the legal expenses, it has to be a one-time legal expenses. There cannot be legal expenses of 15,000. It is submitted that already in criminal miscellaneous, court had granted 8,000 as
To the daughter.
8,000 to the daughter. It is submitted that the wife is working and earning 35,000, and the court, without considering all these aspects, had granted another 15,000 legal under legal expenses and other expenses. Then counsel submits that the almost 80% of his income is granted towards the maintenance, which is not permissible. Next part. Then counsel appearing for the respondent wife submits that the husband has not paid any amount. Then in this MC, who filed the MC?
Is filed.
MC husband has filed
husband
under
has
section 9 of the restitution of conjugal rights.
If he's not paying the maintenance, then file a petition under 151.
That's
That part payment has been made, I think, in that in criminal
No, no.
proceedings.
Part payment is not payment.
It is there, I will instruct that
Yes.
trial court
If it is
advocate.
not, I will also direct the court,
Yes.
an application that is filed by the wife for staying all further proceedings in the MC has to be considered.
I will see that, I will instruct the trial court advocate to comply that court order.
Yes. What did you write? Uh-huh. Has not paid any amount in criminal miscellaneous. It is further submitted that the court has, the application that is filed is saying that for legal and other expenses, and the Learned Counsel has drawn the attention of the court to the affidavit that is filed, wherein it is stated that she has to take care of the child and for her, for the food, shelter and all other legal expenses, she wanted this amount. And the court had rightly considered and granted the maintenance. Next part. Having heard the counsels on either side, there is a material on record. It is undisputed fact that an amount of rupees 8,000 is granted to the wife in the criminal miscellaneous. In the present case, the court had granted 15,000. Admittedly, as on the day the application is filed, the income of both the parties is about 35,000. When already an 8,000 is granted in criminal miscellaneous, on whatever ground, first, the wife is not entitled for maintenance, and second, for the child, granting another 15,000 and legal expenses in these proceedings, in this proceedings, is on the highest side. The higher side. Considering all these aspects, this court is passing the following order. The order dated so-and-so, so-and-so, passed by so-and-so is modified, and the petitioner husband shall pay an amount of rupees 5,000 towards the towards the expenses, monthly expenses of the minor child. He shall pay an amount of rupees 15,000 as one-time legal expenses. Next, if the petitioner husband fails to pay the maintenance, the wife is at liberty to file an application under 151 CPC, and the family court shall consider it in accordance with law.
Grateful.
Bill number 3, Srinivasa K for petitioner, CV Srinivasa.
Respondent, wife, my lord. Petitioner, my lord.
Yes. No,
My
yesterday.
lord, yesterday I moved the matter for adjournment, my lord.
No,
I
how
was
can
held
you
up in Kotal number
that?
15, my lord.
Why was a submission is made before this court saying that you have already informed to the other side?
My lord, my colleague, my lord, has
Can you tell
made,
that?
my lord.
Is it not
You
wrong
might
on
have
his
stated
part?
wrongly or
When the court
something,
is
my lord.
specifically asking, have you informed the other side? Without informing, because I've recorded it also in the order, saying that it is informed, it is submitted that it is informed.
Okay, sorry, my lord. He has not informed me. I think so, my lord.
But I request the advocates, be fair to the court. That is more important.
Okay, my lord.
Yes, argue.
My lord, this case is section 125. The respondent
order
has filed
impugned.
a petition, my lord.
Come to the impugned order.
At annexure C, my lord.
Page number.
The page number 15, my lord.
Sum of rupees 20,000
20,000, my lord.
is awarded to the wife.
The awarded to the petitioner, my lord. The petitioner, my lord, is a working woman, my lord. She is also a
So you are not
70,000.
the petitioner. Wife is not the petitioner.
Wife is a petitioner, my lord. Lord, I am for the wife. I'm the response.
You are
I am for the husband, my lord. Before the court
Before
below.
this court, we are talking about you
Before
are
this
for the
court, I am
petitioner
the-
husband.
Yes, my lord.
Wife is
I am for
granted an
husband, my
amount
lord.
of rupees 20,000.
20,000, my lord.
What? Huh?
20,000, my lord.
What is your income?
My lord, my income is 1 lakh and odd, my lord.
Then what is the difficulty?
This, my lord, this petition, my lord, was filed, my lord. She is also a working woman, my lord. She is a
She's
MCA
earning.
graduate, my lord.
How much
She
she's
has
earning?
filed, this order was passed, my lord, before notice, my lord. Before notice, it was filed, my lord. Thereafterwards, assets and liabilities has been filed by me also. He has also filed the assets
What
and
is your
liabilities,
income?
my lord. Lord, the assets and liabilities I have clearly mentioned, it is 70,000 rupees. And his income is around, what we know of is around 2 lakhs. He works at Virtusa, my lord.
And any children in the wedlock?
Yes, there is a baby girl.
Hmm.
There is a baby girl, and one more submission, if I may make, without hindering his argument, is that he takes around 19 lakhs loan. It makes the wife to take the loan, buys a property in somewhere in Andhra Pradesh without even showing her the property, throws her out, saying it is equivalent to dowry. Now you bring more dowry. I have documents to show to that effect. But anyway, let him complete his argument. I don't want to hinder his argument. This order was passed, my lord, before notice to the petitioner, my lord.
Let us say.
20,000
let
was
us say
passed, my lord.
Wife is earning.
Wife is
income
also
this.
earning, my
Your
lord. She is earning
what
more
is
than
your-
12 lakhs, my lord. She has filed in assets and liabilities, my lord, before the court below.
Take it.
In the assets and liabilities, she has stated that 1,40,000 she is earning, my lord.
Yes.
Now, my lord, the court has granted 10,000, my lord. I have also
20,000.
filed the 10,000 as a interim maintenance to interim order, my lord. 20,000 was has been awarded. paid, This my lord. court changed it to 10,000 and giving a stay. And then after that, he stopped coming to this court. Afterwards, my lord, we have paid the amount, my lord. He is falsely submitting, my lord. It comes to about for 39 months, my lord,
Forget
3,90,000, my lord.
Forget it. Please, when the court is saying something, you have
Yes,
you
yes,
should have the patience
sorry.
to hear to the court.
Okay.
Now, we'll forget about what you paid, what is the order of
Yes,
this court.
Yes,
We are disposing of this matter.
okay.
Court had granted 20,000.
20.
Admittedly, according to you, your salary is 1 lakh and odd. Court had granted 20,000. No doubt it is an ex parte order. Now you agree that it is 1.5 lakh is your salary. Forget about what is the salary of the wife. You have a responsibility towards the kid.
My lord,
The
I
child.
take the responsibility for educational expenses for our needs and everything, my lord. I will undertake, my lord. What are the fees and I will pay, ready to pay, my lord.
Then I'll record like this. All
Record, my lord. Let this.
All educational expenses of the child, educational medical expenses of the child shall be borne by the
Borne by
father.
the
What is the age of the child?
Around born in 2018, baby girl. Before your lordship, please hear me for 3 sentences.
I'll
Only
hear
3
you,
sentences.
hear you.
Huh?
And we'll ask him to take care of all the educational expenses
My lord.
and pay 10,000 per month.
Yes, lord. Let me make my submission. Then whatever order your lordship is going to pass, we shall abide by it. Please hear me for 3-4 sentences. This is my objection along with documents. Because every sentence that the petitioner husband says is a lie. Copy, sir. Lord, 3-4 sentences. My lord. Dates are very important. Marriage takes place on 9/8/2017, my lord. 9/8/2017. Baby is born, baby girl is born on 23/11/2018, my lord.
Yes.
Baby is born on 23/11/2018. He forces her to take a loan of 19 lakhs on 21/2019, my lord. 21/2019, buys a plot, takes all the money from her account to his account, buys a plot for some 4.5 lakhs somewhere in Andhra, which the wife has not even seen. She goes only for registration. He says, this is for our future. But then,
It is in the joint name or in his individual?
it is in joint name. We don't even know what is happening. He buys it for 4.5 lakhs. He takes the other 17 lakhs. I continue to pay the EMI.
How much?
I am paying 40,000. That also I'll show you. I am paying 40,000. For that reason, the lower court ordered 20,000 EMI adru katti nimdu avarinda barali anta anbittu. My lord, then he throws her out on 16/11/2019, my lord. 16/11/2019. We file a 125 petition on 13/12/2021, my lord. 13/12/2021. Interim order was passed on 12/5/2022, my lord. 12/5/2022. On that interim order, he gets a stay on 28/11/2022. 28/11/2022. My lord, he has paid, he has interpreted in his own way. 10,000 has to be paid from the beginning, even though there are umpteen number of citations saying till such time the stay was given, whatever amount was awarded by the lower court has to be paid. He makes his own interpretation and he still owes 1,90,000 in maintenance, my lord. Now, my lord, if I may draw your lordship's attention to 3-4 documents, my lord. 3 or 4 documents. Page number 42, my lord. Page number 42. This is the bank statement of the wife's brother. If your lordship were to go to page number 43, ಕೆಳಗಡೆ ಇಂದ 8ನೇ ಲೈನು, from bottom it is around 6th line, 50,000 and 67,000 paid on 9/8/2017 before marriage. That's why I said dates are important. Marriage took place.
Anyway, we don't have to go into all
One second. Now let me show you the document of the petition for divorce, my lord. Page number 110, my lord. 110.
Now it has come for only
110.
my lord. For the first time he has filed this.
110 is the agreement for the sale agreement. Some property that was bought by the husband taking the loan in wife's name. That loan statement is on page number 80, my lord. 80. 80. My lord, 18,94,652. He takes the loan and subsequent entries are all the money transferred into his account. The loan comes from into wife's account, transfers it, buys this property for 4,25,000. 4,25,000. And then he throws her out with the baby. Even today we are saying, please come and see the baby. He does not even want to come and see the baby. Now, my lord, after this, there is a complaint that is filed. He gets a stay. Immediately he gets a stay. If he files a 482, he gets a stay. He says that I'll pay off the loan that you have taken and you transfer the property to my name, I'll pay it off. That also he doesn't do. Then subsequently, only after all these things, that we file the 125 petition. Now, my lord, if I may draw your lordship's attention to 152, my lord, page 152. This is the assets and liabilities that I have filed before the trial court, clearly mentioning that I make a salary of 70,000. In that, EMI I am paying is 41,548. Expenses for me and the little girl is around 40,000. So the trial court said, you're already paying an EMI of 41,548. Instead of ordering maintenance for the child, the trial court said, take 20,000. That's what they did. And that he challenges, he comes here, gets it, and gets it down to 10,000. Now he's trying to, after that, he has not showed up in the court at all. He has not showed up in the court at all. We've been trying to move the court. And then now he comes and says that 10,000 is enough. Lord, fair is fair. I'll leave it to the court. This is what the story is.
Yes.
Lord, this is
Whether the wife is paying 40,000 EMI or not, ask your client.
40,000 on the top. No, sir, 20,000 something. And may I allow to speak, madam?
20,000.
Hey,
you
what he's
can't,
saying is, what he's saying is,
Huh?
20,000 she has been paying. Other 20,000 he has
That's
been
not
paying.
40,000. No, account shows all that. If whoever is paying, where is that 40,000 every year that?
Account statement starts from page 80, my lord. Every page, there is 41,548 being paid from our account. It starts from page 80. Every page has it, my lord.
How can he make such a statement before the court? Every month 41,000 is.
548, my lord. Every month. He sends the bank fellows from Andhra to Bangalore to threaten her to redo the loan.
Allegations.
And again, my lord, all the documents are here.
Please
That
come.
we have filed
Lord.
a criminal case
And
against.
criminal case, he has a stay. He has demanded for dowry and we have filed the case.
He is saying is, my
My
lord,
lord,
the property is in joint names, my lord. He is also paying till separation, my lord. He has paid the EMI, my lord. But
Separation
what he
is
says, my lord,
2021.
the property may be transferred, we will continue the EMI, my lord. This case is, my lord, the court has ordered for 10,000, my lord. I am ready to pay, I am paying, my lord. Even in the last month also, I have paid 70,000, my lord. According to his statement of objections, my lord, he has stated that 70,000 was paid through the DD, my lord. Or according to him is 20,000 has to be paid. When a court has ordered for paying 10,000, how can I pay 20,000 as arrears, my lord?
Yes.
Therefore,
Agreed.
opportunity may be given, my lord, to
I
put
number-
forth the case of the
I number
petitioner
3,
before the
in
court
criminal
below, my lord.
miscellaneous 659 of 2021, dated 12/5/2022, whereby the court had granted maintenance of an amount, an ex parte maintenance of an amount of rupees 20,000 per month, and ordered notice to the respondent. The petitioner husband has come before this court by filing the presented petition. At the time of admission, this court, and then at the time of preliminary hearing, the coordinate bench of this court had granted stay on the condition that he should pay 10,000. Should continue to pay 10,000. Arrears also at 10,000.
Arrears also.
Arrears
no,
also.
arrears at 20,000.
He said-
As on that day,
He is saying
from
he is
that day, it
calculating
is
20,000.
10,000. Arrears at 20,000.
What is the date of the interim order?
Please, my lord.
Date of
They do not
interim order
mention
is,
it in that.
2022, 16/12/22, my lord.
On 28/11/22, an interim order is passed. In the meantime, list the matter on 9/12/2022. In the meantime, order dated 12/5/22 shall remain stayed, subject to the petitioner paying 10,000 per month and clearing all his arrears till date by the next date of hearing.
Date of
The order is silent with regard to the arrears, whether it should be at 20,000 or 10,000.
As a authority of Supreme Court saying when nothing is mentioned, it has to be at the rate that was ordered by
Not
the
going to
trial.
all that.
Please.
When counsel appearing for the petitioner submits that wife is earning, you have filed your statement of assets
I
and
have also
liability?
filed the
As
assets
per
and
that, what is your
liabilities, my
income?
lord. According to me is 1,10,000, my lord. My income is 10,000, 1,10,000. Her income is 2 lakhs, my lord.
1,69,000 is what is filed.
As per the SSL liability.
Please.
It is the SSL liabilities are filed. As per the same, the husband's income is 1,69,000 and the
In
wife's
2024.
in 2024, and the wife's income is 1,670,000. It is submitted that the court had, when the wife is earning, court had granted 20,000 and she is not entitled for maintenance. It is submitted that this court has reduced it to 10,000 and the petition is ready to pay 10,000.
10,000 and
And he has
also
been-
educational and medical expenses
Education and medical expenses.
of the child.
Next para. When counsel appearing to the respondent wife submits that while they were together, a property is purchased in the joint name, and she's paying 40,000 and odd as monthly maintenance.
On the EMI.
EMI, a monthly EMI of 40,000, and apart from that, she has to take care of the child. Considering all these aspects, court had rightly granted the maintenance of an amount of rupees 20,000. It is submitted that the counsel has submitted on the merits of the matter, how the wife has been thrown away from the home, and all those things are not relevant for the purpose of the deciding this application. The husband is present before the court. He doesn't deny the fact that the loan is taken, and even the account statement that is placed before the court clearly shows every month towards the EMI an amount of rupees 40,000 is deducted, and the wife is left with only 30,000. When the husband's income is 1 lakh and odd, the court had rightly granted an amount of rupees 20,000
Statement.
pending consideration of IA number. It is a expert
Number
order,
one,
pending-
expert team.
pending consideration of IA number 3. In these circumstances, on the facts on record, this court do not find any reasons to interfere. Accordingly, the
Statement has been filed till 21, my lord.
writ petition is dismissed. The court shall pass appropriate orders on IA number 3 within 1 month from the date of receipt of the copy of the order.
And pending arrears of maintenance to be cleared immediately.
Whose MC is that? The MC is also filed?
MC is also filed, I think.
He has filed a divorce
Filed by
petition,
whom?
my lord.
Wife.
Filed a
Wife.
divorce petition and also.
Because he's not willing to
498
take her, he's not willing to take the child
But
also.
if he is not paying the arrears, then file a petition under 151.
We have, my lord, arrears may be
Interim
cleared
may be
immediately.
fixed, my lord.
Direction may be given to him to clear the pending arrears.
No, he has to be
But
disposed
how
of,
can
my lord.
if the arrears are
May
not
be
paid by the
disposed of
husband,
within 15 days.
Yeah,
my
we,
lord.
we
That
have
IA may
liberty
be-
to move under 127.
if the arrears are not paid by the husband, the wife is at liberty to move an appropriate application of 151C.
That
Yes.
IA may
Much
be-
obliged,
time frame may be fixed for disposing the IA, my lord, within 2 weeks, my lord.
It's already fixed at 1 month.
He will drag on, my lord, by saying some other things, my lord. Some
Yes,
time frame may be
please.
fixed. I am ready, my lord.
The
Why is
counsel,
shying away? my
can't you
lord?
hear what the court is saying? Court is loud enough. I said 1 month. And again you are asking.
My
I
lord,
asked
what he
him,
says is, my lord, for arrears of maintenance, my lord.
I said to
within 1
dispose
month.
of the IA within 1 month. I already
In the
said
meantime,
that.
in the meantime, he wants arrears, my lord.
Yes, arrears also have to be cleared. Yes, next.
Cell number 4, Rangaramu B, for petitioner.
Right from. Hmm? Why? To whom? He didn't say so. What did he say? No, he didn't say anything that he will pay. He has to be here when the matter is called. There is no representation on behalf of the petitioner on 6/8/2025.
Permitted to withdraw it.
Huh?
I mean, permitted to withdraw.
You are here only, your matter is called, and I'm going to pass orders on that. Where is the withdrawal petition?
I'll file the memo.
Give the memo. A memo is filed seeking to withdraw the petition. Accordingly, memo is taken on record and dismissed on as withdrawn. Yes, next.
Cell number 5.
Madam, I'm appearing for the respondent.
Memo is for
What are these office objections?
From 2003, they are not complying.
Will comply, my lordship.
Why
My
will
kindly,
comply? No,
my
no,
kindly.
will not grant any time. Why are you not complying? How many times this matter has come up? No,
Lordship.
the process of the court is taken for granted just like that.
No, my lordship. Kindly, my lordship.
After taking interim order from this honorable court,
That's how it is
no, they are
happening
not
in every
making
case.
My lordship kindly will last as my lordship. Will kindly.
No last chance.
No, my lordship kindly.
Please,
Kindly.
please argue the matter.
Definitely, my lordship.
Argue the matter.
My lordship.
There is impugned order. Page number?
my lord, page number 40 is the interim
40.
40, my lordship. Last operative portion of the order.
Petition is entitled for rupees 10,000 per month as interim maintenance till the final disposal litigation expenses of 25,000. What is your income?
My lordship.
8,000, my lord.
Let him say yes.
My lordship, earlier it was 68,000. Now I am earning around 50,000, my lordship, because of other issues in the companies. And since
What is her income?
my lordship, her income as per then described, 40K is her income, my lordship.
Children?
No, my lordship, no children.
Then how the wife is entitled for maintenance?
That is the concern, my lordship.
Why is she entitled? How can you, when she is earning 40,000, husband is earning 60,000, even assuming that?
Kindly.
Like, is it like a balancing that husband, it should be equally distributed between the parties? No?
My lord, he is residing in his own house,
Still,
whereas the respondent is residing in the rental house. During the time of marriage, the respondent parents spent amount of rupees 11 lakh, and they have to pay the interest. They have borrowed the money from the money lenders.
for that
Apart-
maintenance will not be
That
granted.
not comes under this.
I would kindly say, the marital life continue only for a period of 8 months. After pregnant, my lord, due to medical reason, she got aborted. Thereafter, he ill-treated and obtained the consent letter for divorce forcefully and sent the respondent to his house. Thereafter, he filed divorce petition. My lord, he also tampered. My lord, he is working in some private company. My lord, she is receiving only 30,000 ad. That too after recovery of her ill health. Then, my lord, she tampered the PF account of the respondent. Then she made a complaint to the police. Police registered.
That will be independently decided.
Then, my lord, thereafter, my lord, he withdraw the divorce petition. Now, my lord, he put a lot of trouble. But you kindly see, he is having his own house, own car, as well as the 2 sides, and there are number of properties are there. On the other hand, she is residing in a rental house. My lord, law laid down by the appeals court is very clear. The status of the parties has to be taken into consider. Here, my lord, the status of the husband is more better than the wife. Lordship, kindly see, my lord, para number 79 of the judgment.
Take that.
40,000 very strong submission. He is receiving only 30,000 net. On the other hand, my lord, the respondent in his own statement he stated that he is receiving 68,000. Lordship, kindly see. The asset and liability filed by the husband shows that he is receiving the monthly salary of 68,000. It is
How
not
much
correct.
percentage of the husband's income can be granted as maintenance?
My lord,
What is the percentage of income of the husband's salary can be granted towards maintenance?
as held by this honorable court, my lord, 1/5 of the salary of the income of the husband can be taken as the maintenance.
What is the income according to you?
More than 1 lakh, my lord.
Where is the material?
68,000 is the salary. Apart from that, he is doing some private.
What is the evidence for that?
My lord, he is a M.Com graduate.
There is
True. Court can only look at the evidence, but not what the wife assertion is. So the income is 68,000. And according to him, your
He is
income is.
doing some private
That,
auditing.
for that there is no evidence. There is no evidence for that.
And residing in his own house and also getting some rental income.
40,000 is your income as per the statement of assets and liabilities. His income is 68,000.
30,000 only wife income is only 30,000.
Where from you said it is 40,000?
My lordship, in the affidavit, she has stated, no job, my lordship. But as per the other records presented by them in the then court, it was 35 to 36K, including the incentives and whatever the other privileges she has been enjoyed, is about 40K, my lordship. Currently, the salary is more than the increment, and whatever was considered, it's more than 80K, my lordship. From past 2 years, the increase, the income has been.
The land counsel for the.
According to my client, my lord,
The land
para
counsel
number
for the
17 may kindly be seen, my lord.
And we
One
have
minute.
also made a judicial deposit, kindly.
And counsel for the petitioner submits that the wife's income is 80,000 per month as on today. Land counsel for not land counsel, the respondent shall file an affidavit in that regard. What is her income as on today? This is matter on 24th of September. Yes, next.
Number 6.
Kindly,
And
madam.
by 24th of September, the office objection shall be complied with, or else an amount of rupees 20,000 shall be paid to the Advocates Association.
Cell number
Great.
6. Ajay Prabhu.
My lord, I filed a memo for acknowledgement, having served copy of writ petition on the counsel appearing in trial court for respondents, my lord.
What is the name of the advocate?
It is Pinto, my lord.
Where did you say? Time
My
and
lord,
again.
no, my lord, he has put seal on the memo of acknowledgement itself, my lord.
But you know why? What is that the advocate will lose saying that I have served the copy on so and so advocate appearing for the respondent. Such a easy thing. Time and again, every day I'll be repeating this, but nobody is doing it. Yeah, it is a
But we
memo is
have-
filed as per the order of this court. The petitioner has served the copy, served the notice on the counsel appearing for the respondent before the trial court and filed a memo to that effect. Print the name of Praveen, Mr. Praveen Pinto.
Pinto,
This
Please.
is matter next week. Next.
Cell number
please.
7. Cell number 7.
Bill number 7, I am appearing for petitioner, your lordship. I need some more time to produce the copy of the proof, your lordship. I have to get it from the Gulbarga.
This order is passed on.
3/9, your lordship.
How much time you require then?
I have to go to Gulbarga and I have to get the copy, your lordship. I have applied for the leave. I have not got the leave. That is why it is delayed, your lordship.
Either you come up with that copy or without looking at that copy, I will hear the matter on merits on, let's just matter on 19th. By
Please,
the
your
time,
lordship.
if the copy is
Interim
not
order may be
filed,
extended, your lordship.
this court will hear the matter on the merits of it.
Please,
Interim
your
order earlier matter is extended till then. Yes, 8.
Cell number 8.
Oblige, your lordship.
F. Shweta D. Rao.
Respondent.
K.
For dismissal tomorrow. No representation. Yes.
Cell number 9. Rupesh Kumar S. for petitioner.
For the respondent in the matter, the registry of the Sambal Court matter made me file a personal affidavit. Though my file put up the
What is this
Clear
idea
it,
number
my lord.
1 of 25 for recalling?
recalling the order matter. My name is K.A. Chandrasekhar. Office of the Sambal Court matter put up the caveat in the name of K.S. Chandrasekhar.
Where is the caveat, let us see?
Please, madam. Page number 6, madam. Page number 6 of my IA. They served the copy on me, other side. Even the cause list,
It is what it is. It is what you
It- it-
signed. K.A. Chandrasekhar.
yes, my name is K.A. Chandrasekhar. Page number 13, please, my lord, cause list.
Yes, Mr. Counsel.
They served the copy on me also, but I am not blaming other side. My name is K.A. Chandrasekhar.
No,
but
with the cause
you would
list,
have
his name is printed
brought
wrong.
me here.
Yeah, I agree, my lord.
We will recall this order and hear the
And
matter.
otherwise, the matter was heard on merits, my lord.
No, it is
was decided-
observation, my lord. It is page number 3 of the order as well as in the body of the order, my lord.
Could be recalled, my lord. I'll address my argument.
Please,
I will
please,
try.
please.
Where is the order? This court on 15th July 2025 has disposed of the writ petition. In the order, it is observed at paragraph number 3 of the order, it is observed that though caveat is filed, there is no representation on behalf of the respondent caveator. And further observed that this matter came up before the court on 9/7/2025 on the day when counsel the petitioner is present and there is no representation on behalf of the respondent caveator and directed the matter to be listed on 15/7. Today also, when the matter came up, there is no representation on behalf of the respondent caveator. Hence, the court deems it appropriate to pass a final order as sufficient opportunity is given to the respondent. Now, when IA is filed, recalling the said order, it is stating that the advocate's name is KS Chandrasekhara. KS or KA?
And KA.
KA Chandrasekhara, but in the list, in the cause list, it is printed as KS Chandrasekhara. And even in the caveat also, the Vakalat is very clearly showing that his name is KA. I think in so many cases they are printing the wrong names. No, you're not you instructor. Tell the registrar judicial. KA in the what did you write? Also, it is clear this court has perused the caveat Vakalat. It is shown as KH Chandrasekhara. It is submitted that as the name of the advocate was wrongly reflected in the cause list, he is not aware of the listing of the case and he couldn't appear. As far as that is concerned, then counsel submits that the order as far as the paragraph number 3 may be recalled accordingly. The order dated 15th July 2025. As far as paragraph number 3 is concerned, we'll delete this paragraph then.
Yes.
Paragraph number 3 is deleted and it should be substituted as heard the learned counsel for the respondent. Heard the learned counsel for the respondent. Yes. Yes. Yes, next.
And
Yes, this
my lord, in last para, please, my lord, page number 4. Last 5 lines, my lord, it is. However, considering the fact that in spite of spending an amount of rupees 40,000 towards the school fee, the mother is not sending the boy to the school and mother has not chosen to come up before this court and explain whether the case is not the case that is also, my lord, required to be.
Then in paragraph number 4, from however, till husband is correct or not, that also delete. And the order shall be uploaded. Yes. Corrected order shall be uploaded. Yes, next.
That there be inquiry or not, my lord, against the registry of the Sambha court.
We'll look into that.
Please, my lord. Otherwise, my lord,
No,
it
not
should
only,
not be.
it's
It
not
shall not
about
be
inquiry.
repeated is my request, my lord.
But it's happening in some of the cases, like they are wrongly like.
No, my lord, my clients are, my lord, preparing to move before the bar council, my lord, against me, taking all these developments, my lord.
Yes, next.
Number 10, Chandrasekhar for petitioner.
Respondent, my lord.
Prakash.
Appeal for the respondent.
Why each page is
By mistake, actually by mistake, and we'll correct it today.
Yes.
My lord, kindly have it to Monday, my lord.
Why? Today is not an auspicious day.
Senior not well, my lord.
Give that. Even for these small writ petitions also, why the senior's presence is required? Office of give him the objections.
Already given.
Give him the objections, he'll sign it off.
Yes.
Then counsel appearing for the petitioner, respondent submits that he will clear the office, the objections right now by signing the each page. Yes, this is matter in the month of October.
Cell number 11.
Yes.
Cell number 11. SB total.
Lordship permits, my lord, I will file additional documents which were not in existence at the time of filing of the application for vacating stay.
What are those documents?
Her medical documents and
You have
premium
to
paid
give him a copy
certificate.
of it.
Yes, now they served me the copy, ma'am.
Land counsel for the respondent has served the.
I'll file it in the office.
Land counsel for the respondent submits that she wants to file the additional documents and she has already served a copy on the council. List this matter in the month of October. Yes.
Cell number 12.
Please.
Cell urgent. Cell number 13. Cell number 13.
Yes.
And Gautam Raghunath.
Lordship, necessary application has been filed for the substitute service, Lordship.
13 is
13.
Where is the counsel for the respondent?
list 1.
List 2.
Madam, list 1 kar diro.
Yes, where is the counsel for the respondent?
Anupama Bordoli.
Where is your advocate?
My lords, may
Let her come, we'll see.
problem is I'm not available in the second half. That being the reason. Tomorrow, my lords.
Let her come, now itself will take.
Please,
Let the advocate come.
Yeah, please.
Only pass over, he has some difficulty.
In the afternoon. My lords, I will,
He can
what
continue.
happened day before, what my learned friend submitted.
He can continue, my lord.
One second.
She's downstairs.
What my learned friend submitted is absolutely true, and the respondent unconditionally apologizes before this court that she could not inform them regarding her travel.
It's not about apology, Mr. Gautam.
Please,
It
I
is
have
about the
advised, I've advised her, my lords, I've
It is
advised.
about the conduct.
Please,
So, in spite of giving opportunities, the nature is like that.
No,
Which
visitation
is
rights
not-
have been exercised. my
Not,
lords.
which is not in the interest. No, children are regularly, now they're regularly talking to her, they are in touch. One fine day, for 3 or 4 days, you will vanish. If the children have any,
What she is informed is, she is not in, she's told the children that she would not be in town, but regarding the WhatsApp call was not told to them. That is, in fact, I advised her it's not right. My lords, she is in fact before the honorable court, she's.
nobody is asking you to stop your livelihood and stay at home. But you have, that shows what has been now all through, Mr. Gautam, what has been done earlier and what is happening now. It only shows that there is no change in her attitude. So, what is, no, the court is not concerned about the mother or the father. Court's concern is about the child. So what confidence this court has that the welfare of the child is with the, being with the mother. Tell your advocate, unless and until the court
My lords,
asks, you shouldn't
no,
respond.
My lords, I would in fact not even delve into that, my lords, because earlier there have been instances wherein she was blocked. I'm not bringing that before lordships now. What has been done is wrong. We've advised her and she really apologized. She'll ensure that she'll keep the father informed henceforth. The problem is the problem is on certain occasions, even prior to this incident, when she's tried to, whenever a video call she's made an attempt, she's usually blocked. That is the issue. I have produced WhatsApp messages also to that effect. Please wait a second. I have produced WhatsApp messages as well to that. But my lords, I will not press on that. I have advised her.
What the court can see, Mr. Gautam, there is absolutely, I think the father is very cooperative.
Please.
And if he is not looking at what interaction this court has, the children wouldn't have come to her at all.
Please.
So the father is facilitating. Let us not make any
That's
blame
the
on
reason I'm
father.
not even getting into that aspect
We
of the video
shouldn't,
calls, my lords.
because mother can't afford to make any complaint against the father
Please,
for what he
sir.
has done and what he has been doing. So yes, what should follow?
Yes, my lords, also I have been continuously threatened by sending PCRs, saying
Sending
that
the-
I have filed police complaint against you for
When-
taking my children away.
My lords, this was at that point of
No,
time, my
now,
lords.
recently, 2 days back, my lords.
Take that.
Along with the message I have sent.
My lords, the PCR was filed in February prior to the
No, they are
proceedings.
speaking about Mr. Gautam. Give him a copy.
Copy, please.
Give me that. It is- Yes. That's, this is the message.
Which is the message? Which page number, ma'am?
First page. 1 second, I'll give another.
I have the wrong one, I think. I in fact have advised her not to pursue that PCR for the reason being.
Don't advise her anything. Don't advise her. Let her do what she wants. We will pass orders, what is in the interest of the children. Is she completely lost mind or what? What is this? At one stage, well, at one thing, you want the husband to cooperate and you do all these things. I'll pass a final order, Mr. Gautam. This is not a case we
My lords,
require
may at least-
any kind of indulgence of this
My
court.
lords, may at least verify this. I mean,
I'll have it tomorrow. I'll pass final orders.
Please.
I'm going to confirm the order passed by the family court. I'm telling it very clearly. Let her not come to the court, Mr. Gautam.
Please, my lords, please.
Let us not come to the court. If she want to talk to you, let her talk outside the court.
Please.
Yes, next.
Cell number,
List this matter tomorrow.
cell number 14. Sharat Gowda, GB. 14, Sharat Gowda. Punisha,
Here for the
NS.
petitioner. A case for maintenance. My lord,
Who appears to the respondent? Yes.
respondent, my lords. With
You're questioning both of, you're seeking
My lord, I am
enhancement.
seeking enhancement. I appear for the
Vote for
wife.
the wife.
Yes, my lord.
Where is the impugned order?
My lord,
My lords, on the previous occasion, the honorable court has directed to me file the income tax returns. May I be permitted to file on today itself because I have received the income tax returns on yesterday. A week time may be granted, my lords. I will.
Does this matter on 18th of September? Huh?
Please, my lord.
18th of September, by the time the counsel for the petitioner, the counsel for the husband shall file the income tax returns by serving a copy in advance on the counsel for the wife. Yes, next
Cell
15.
number 15. Mallikarjunaya case for petitioner. 15.
Yes.
Lordship, appear for petition, my lord. Last date appearing lordship is asking me to file affidavit of assets and liabilities. I already filed. in the
Where is it?
Last date was, I asked you to file assets and liabilities of both the
Look at
parties.
it.
ಒಂಬತ್ತನೇ ತಾರೀಕೆ ಫೈಲ್ ಮಾಡಿ 9th itself I have filed. I'm having one copy.
Take that. Where is the impugned order?
Impugned order at page 15, my lordship. IA number 1.
Hmm.
IA number, it is 17. IA 1 filed by petitioner under 125 CPC is partly allowed. Respondent is by directed to pay 10,000 per month for maintenance of the child.
Hmm. So on what ground you are before this court?
I am a jobless. In my petition MC 68 of 2000. Kindly see page 15, my lordship. Up to kindly 15. The trial court has stated.
Hmm.
He has also that there is already ordered an interim maintenance.
How much
Yeah.
you are paying?
In MC, I am paying 5,000 per month regularly. I am already paying.
Then let us see how the court has considered this and passed order.
Based on affidavit, this court has passed order 10,000. I am jobless now.
Page number, paragraph number 9 of the impugned order, please read.
Yes, my lords. Shall I read the order?
Please read paragraph number 9.
Paragraph number.
9 of the impugned order.
The respondent has filed his affidavit of assets and liabilities and is MBA qualified, and both of them are residing separately from 16/7/15. The respondent has stated that he has borrowed loan from his mother and brother. He also stated petitioner is working as assistant professor in RNS Institute. The petitioner has not produced any document relating to income of the respondent. The petitioner and respondent are well qualified. Therefore, the petitioner one is not entitled for any interim maintenance. It is admitted that the child is with the petitioner mother. Both the parents are equally responsible for bear the expense of the child and also maintenance. Now it is just necessary to direct the respondent to pay 10,000
Then
per
counsel
month.
for the petitioner submits that already he's paying an amount of rupees
5,000, my lord.
5,000 to the child in MC number 68 of as per the order.
That's if I'm relying on this decision also without evidence,
As per
basing
the-
on only
as per the
affidavit.
order, as per the order passed in MC number 68 of 2016. It is submitted that the court again has ordered an amount of rupees 10,000 according to the petitioner is unemployed. Considering all these aspects, they shall be stay of all further proceedings on the condition that he shall pay
And also suffering
5,000
from TB, my lord.
5,000 by 5th of every succeeding month, and the arrears also at 5,000.
I'm relying upon the decision also with
We'll see the decision in the May at the time of hearing, not now, for interim order. Just 60 and it shall take the hand summons and file a memo to that effect by 8th of October, or else even on the stay granted by this court stands vacated.
Then
Just 16.
Deepa J, petitioner.
I pay for the respondent, my lord. Lord, we've entered appearance this morning and summons was served a few days ago.
On 2nd of September, when this matter was listed, your lordships, you'd asked me to serve the copy. I have served on 3rd itself. I'm pressing on the interim prayer in this matter.
What is interim prayer?
May I request your lords to kindly look into the order sheet, my lords? They had not, once again, my
Let
lords,
them
once
come,
again.
let them come.
My
No
lords, they had
urgency for
not even
this.
filed their objections in the trial court. They didn't argue the
Heard
matter.
them, we'll hear them.
Your
When
lordship,
it
may grant
counsel
2
so
weeks
and so, not 2 weeks. It will not be 2 weeks. Then counsel for the respondent. So and so submits that they have instructions to file wakalat. This is matter on 18th. Yes, next.
Then number 17.
I appeal for the respondent in this matter, my lord. A small submission. My lord, the matter stands settled between the parties. It is under a stage of filing the joint memos and the affidavits. A week's time may be granted, my lord.
It is submitted, the matter is settled, and they'll come up with the joint memo. This is matter on 19th. Yes, next.
Then number
Obliged.
18. Then number 18.
Petitioner. Appealing for
Venkatesh
respondent.
R.
Filing my memo of calculation.
Rajendra VG.
They have filed the memo of calculations, my lord. The payment is not in He dispute. has filed memo of calculation, my lord. Payment is not in dispute. Now, my lord, in the earlier occasion, I had made a submission, my lord, that the trial court had passed an ex parte order granting 20,000 as maintenance. And this court, my lord, by its order, my lord, stayed the impugned order and directed me to pay 10,000 per month, my lord. And that I have been paying it, my lord, all along. Now, in their memo of calculations, what they say is they are calculating it from the date of petition. I am calculating it from the date of the order of the trial court, my lord. 2 months is the difference, my lord. I'll leave it to the court, my lord.
20,000 also.
Yes, my lord. I'll leave it to the court, my lord. If the court directs, I will pay the that amount as well, my lord. Now, the petition is of the year 2019, my lord, before the trial court. If this arrangement is continued, my lord, 10,000, I will continue paying that till the disposal of. It's all almost in the stage of the petition is that
Is it
for
criminal
respondents'
miscellaneous or
evidence.
MC?
Please, my lord.
Criminal miscellaneous or
Criminal
MC?
miscellaneous, my lord.
So we'll direct the court to dispose of the matter within 3 months.
My lord, kindly
No.
come to page number 16
Whatever
of
is
my
the
statement
arrangement
of objection.
whatever is the arrangement that's going on, let it go on.
My lord, respondent number 1 is paying 11,000 every month for educational expenses of the respondent number 2 and 3, my lord.
What is the order of the court? Come to the order.
The maintenance, my lord, was granted at the My lord, rate page of number 20,000 per month. Page number 23, my lord. Fourth line from the bottom. Page number 23. Page number 23. Accordingly,
Page number
fourth-
23.
23. Fourth page line 20. from the bottom.
Accordingly, respondent is directed to pay ad interim maintenance of rupees 10,000 to the petitioner and rupees 5,000 each to the children. Apart from the above, respondent is hereby directed to pay entire educational expenses directly to the concerned
No,
school.
10,000 plus 5,000. 15,000 is
Five each
granted.
will be 20, totally it will be 20,000.
Totally 20,000. Apart from that, the trial court has ordered to pay entire educational expenses.
Why do you get that?
Till date, he has not paid any educational expenses, my lord.
Then what is your income?
My lord, now, at the time when earlier, my lord, he was working as a financial associate, my lord, and was drawing a salary of around 20,000, my lord. Thereafter, my lord, he quit the job, my lord, and he pursued his law, my lord. And now he is an advocate, my lord. He is working as a junior in an advocate's office, my lord. Tentatively, his income as of now would also be the same, my lord, 20,000, 15 to 20,000. That will be the average that he is earning. I have produced the enrollment certificate also, my lord, which is there at page
Before the
88.
court, you have not filed your statement of ethics on liabilities.
Please, my lord.
Before the court,
No, my lord, I have filed my statement of objections, my lord, to the application also after my appearance. The trial court has not considered the application yet, my lord. After my appearance, this is an ad interim ex parte order, my lord.
Yes, we'll set aside this. And let them continue to pay and let the court decide. Agreed with the orders passed in. Agreed with the order dated 8/1/2020, whereby the court had granted 10,000 maintenance to the wife and 5,000 each to the children, and also directed the husband to pay the educational expenses. The husband is before this court. It is submitted that it is an ex parte order. The court had not considered it is not court. It is submitted that his income is 20,000 and paying an amount of 20,000 to the paying 20,000 as maintenance to the children and the wife, and also paying educational expenses is beyond the financial capacity of the husband. It is submitted that the order needs to be set aside as this is simultaneous of 2009, and he will be, as per the interim order, is paying 10,000. He will continue to do so, and there shall be a direction to the court to dispose of the main application itself. Next para. When counsel appearing to the respondent submits that there are at least another 20,000 is due. Another 20,000 is due.
40,000.
40,000 is due.
As per the interim order, it will be 22 months. The difference is 2 months. So
2 months, let's say 2 months.
Yes, ma'am.
2 months amount is due, and it is submitted that that the court has directed to pay the educational expenses also. So far, no amount is paid by the husband. It is submitted that it's a obligation, responsibility of the husband to take care of the wife and the children, which he has failed to do. Next para. Having heard the counsels on either side, there is the material on record. This is an ex parte order. There is nothing before the court. What is the income of the husband and what is the entitlement of the wife and the children? And considering the fact that considering the submission of the land counsel, the petitioner, that the income is 20,000. His income is 20,000. This court deems it appropriate to set aside this order. This court deems it appropriate to direct the husband to pay an amount of rupees 10,000 pending disposal of the petition. And the court, as this is a C miscellaneous of 2019, the court shall, which court is this? The court shall dispose of this matter by December, by 15th of December.
Please.
Number 19. Anand Muttali, A.S. Bimaya for respondent.
Appearing for the petitioner, Your Honor. We had taken the child for counseling on 6/9. However, since there was no direction received by Nimans from this honorable court, and we had also not been able to obtain the certified copy, they directed us to come back after the direction. Yesterday, my client received a call from Nimans stating that they have received a direction from this honorable court. And accordingly, the child was asked to be kept present in the morning. Today, she is already there. Even the respondent is there.
Both of them are.
I'm filing
So
a memo to this
will-
extent.
Huh? No, no, anyway. It is submitted with the land council that today both the parties are before NIMHANS as per the earlier order passed by this court on 21/8/2025. Plus this matter, once a report is received from the NIMHANS. Huh? The letter is regarding so and so from the Registrar General of the High Court of Karnataka. Mother, father and child have reported to OPD without court order. The report shall be placed before this court once evaluation is done. Yes, next.
Sale number 20.
I appear for the petitioner, my lords.
Yes.
The petitioner has been complying with the interim order of this honorable court.
Where is
However,
the counsel for the respondent?
I appear for respondent in this matter, my lord.
Yes,
The
let's please argue.
last date of occasion, court has asked me to file the memo of calculations, the pendings, whatever the still.
Anyhow, we will hear the matter and dispose of that pending calculation. We can see that can be done in the EP. Yes.
My lord, education fee, it has not been paid, my lord. That's the main this thing, my lord. From
We
the
will, no, you can file the EP. Yes.
My lords, the present petition, my lords. My lords, am I audible, my lords?
You are audible. Where is the impugned order?
Impugned order is at page 55, my lords. Annexure D.
Page 55.
55, my lords. This is a part of the order sheet,
Mm.
wherein interim maintenance of 10,000 of each child and educational fees.
That is 20,000 is awarded.
Please, I have been continuing to pay it. But however, further, the respondent is hereby directed to pay the entire arrears of maintenance to the petitioner from the date of the filing of the petitioner. Forthwith is what the order is, my lords. Now, my lords, the petition was filed in the year 2019, my lords. I entered appearance in the year 2023 because the notice of the was not properly served upon me, my lords.
it was served, my
However,
lord, and it was avoided.
let me make my submission, sir. Please, sir. Then, my lords, I filed my objections. Further, my lords, I was supposed to file my assets and liabilities, my lords. What happens is the petitioner, previous to my appearance, had filed his assets and liabilities. However, my assets and liabilities was not taken into consideration, and accordingly, my lords, the impugned order is passed, my lords. On this grievance, my lords, I have filed the writ petition, seeking an opportunity to file my assets and liabilities and let the court make an objective assessment to that effect. And an order may be passed, my lords. I'm not shying away from paying anything, my lords. However, an objective assessment has to be made.
I'll also direct the court to consider from which date this order has to be operative in the sense, because without even notice to the respondent, this order is passed.
No, my lord, it is deliberately avoided to receive the notice.
That the court will decide now.
Yes,
The
ma'am.
family court will decide. Yes.
Within a time frame, man. Within a time frame, man.
Yes, yes, yes. The present writ petition is filed. Agreed with the order passed with the family court dated 17/7/2023, whereby interim maintenance of an amount of rupees 10,000 is granted to each of to the wife and the child, and also educational expenses of the child is awarded, and the husband is directed to pay the entire arrears of the maintenance to the wife from the date of filing of the petition. Learned counsel appearing for the petitioner submits that the petition is filed in the year 2019 and the notice is served in the year 2023. From the date of order is paying the maintenance of an amount of rupees 20,000, but
Now,
granting
my lords, if I may, my lords, now he is being paying 30,000, my lords, from 2 months.
Paying 20,000 from the last 2 months.
But whatever, since it
He's paying
has not been
30,000.
paid, my lord, 30,000.
It is submitted. It is his submission. You can make your submission. And
Yes,
he's paying 30,000. It is submitted that it is submitted that the court without even looking at the statement of giving an opportunity to file the statement of assets and liabilities, file the petition, has passed the order. It is submitted that if When the petition is filed in 19, when he has entered into appearance in the year 2023, there cannot be a direction to pay the maintenance from the year 2019. Hence, it is submitted that the order may be set aside and the matter may be remanded back to the court. Next part. Have the learned counsel appearing for the respondent submits that. According to you, what is the amount to be, is he paying?
My lord, just now I confirmed it, from a few months, 30,000 is been paying, madam. I've just confirmed, madam.
He does not dispute the
I
fact
was not
that
aware
in
of
the
that,
last
that's
2
why.
months, the father is paying 30,000 and before that, he was paying 20,000 from the date of order.
Yeah, the order of this honorable court.
From the date of the order of this court, the learned counsel submits that the petition, the husband wantedly has avoided the notice, and on that ground, the maintenance cannot be directed to be paid from the date of his appearance. Court had rightly observed that the maintenance is from the date of the order, from the date of the petition. Next part, having got the counsel on either side, peruse the material.
And the school fees, it may be recorded, my lord.
The school
It
fees
has not been paid.
is not paid. Next part. For the learned counsels on either side, there's the material on record. This is an MC.
Time frame, my lord.
December 15th.
Time frame.
MC
December,
of the
please.
No,
MC
within 3 months, let the matter be disposed of, my lord.
December 15th, not before that. MCs of the year 2019. The husband has entered appearance in 2023. Whether there were lapses on the part of the husband, why the contention of the wife that he avoided, all these aspects this court at this stage cannot decide. As the husband is paying 30,000 per month as of now, this court deems it appropriate to dispose of this petition by passing the following order. 1. The petitioner shall continue to pay an amount of rupees 30,000 till the disposal of the petition. Both the parties shall file their respective statement of assets and liabilities, and the court, along with the main petition, shall decide the entitlement. Coming to the aspect whether it is entitled from 2019 or 2023, looking at the material on record, the court shall pass appropriate order. This is MC of 2019. Hence, this court deems it appropriate to direct the court to dispose of the matter by December 15th.
If I may make one submission, the matter is right now in respondent evidence, my lords. If the time period may be extended for some time, rather than December 15, my lords,
Let's say by February.
February, my lords. By end of the February, my lords. Please, my lords.
By end of February 2026.
At least a part of the school fees may be paid, my lord, because from first
Now,
term it
this
is not been.
application, this IA, then I said it should be decided along with the main petition. No, they shall file the respective statement of assets and liabilities. With regard to the educational and the other maintenance, the court shall decide the application within 1 month from the date of receipt of the copy of the order.
Say number 21,
Alright.
object, 22. Sagar V. Shastri for petitioner.
Yes.
So the petitioner.
No further adjournments will be granted.
Please, the parties have been staying for the past 5 months and have come to some
It
settlement.
is submitted that the
I may
parties
be-
are residing separately. A memo is filed in that regard, accordingly dismissed as withdrawn. Next 23.
Say number 23.
My lord, senior is engaged in another court hall. She'll be coming.
Every day the Passover business won't run.
Lord, please, my lord, she'll be
From
coming.
the last 3 occasions, every day Passover is sought.
Please, my lords.
No, it can't be done every day. Passover 24.
Say number
Your Ladyship,
24.
may I request if Monday, because second half I have another argument. Either Monday or
Or
Tuesday.
else we'll have it in the month of October. Let's just
No,
matter
my lords,
in the
please,
month
my
of
lords, she'll be
October.
coming.
Court has no time.
My lords, please.
For every day. How many
Please,
times?
She'll be coming, my lords. She's another court hall. Please, my lords.
I have.
My lords, please, my
This
lords.
is matter on 8th of October. Yes,
My
next.
lords, no, my lords, please, my lords.
Yes.
My lords.
24.
For the respondent,
Not the-
the 5,000 rupees,
Suresh P.
Yes.
kindly dispose of the matter. The 5,000 rupees was ordered for minor child. He is not going to school also.
No.
She is a double graduate.
Let's see.
He is
From the
working
order.
as
Where
a
is the order?
My lord, the page 92,
page number 92, my lord.
the 5,000 to the
respondent
minor child.
towards the maintenance of their minor child, Yukti P.
The petitioner shall pay interim maintenance of 5,000 to the respondent towards the maintenance of their minor daughter. What was it question?
My lord, she is 5 years old now. She is going to the UKG. The school fees itself is 50,000 rupees per annum. Only the 5,000.
What is the expense of what is the income of the father?
The respondent in the family court, she is not working. I filed my assistant liability
We have also filed a.
because
You are appearing for whom?
I'm appearing for wife.
You are seeking enhancement.
Please,
I said, what is the income of the husband?
husband is 20,000 rupees per month, but they are not disclosed anything because he is getting rental income from his house and also agriculture
You should
income.
disclose. Either you should disclose or he should disclose.
I have
Because
disclosed.
that court can't assume anything.
20,000 rupees he is getting salary. My lord,
That's
my lord,
all.
kindly see the page number.
And what
11.
about you? What are you doing?
I'm not working, my lord.
She is a
Because-
MSc graduate, biotech,
Because
BSc and MOTech,
2019 I was working.
working as a lecturer.
No, part-time working.
We can increase it by another 1,000, not more than that.
Please kindly see the page number 11.
We can't grant maintenance beyond that.
20,000 rupees is the
Because
salary.
my lord,
You admitted that it is 20,000 salary.
Because-
Beyond 30% can we grant maintenance?
my lord, he is a BE and he is a mechanical engineer. How can you believe 20,000?
Court will not assume all these.
Because my lord, he has not produced these 3 years bank account statement before the
Why?
trial court.
Why you are not filed?
We have filed.
Just in kindly see this assistant
kindly page number
liability.
59.
Only has produced the,
Kindly page number 59, his monthly income, details of income of the department. Page
he is
number
getting
59.
incentive also. They are not disclosed
Now,
anything.
filed the-
That is the apprehension.
Before the trial court,
What do you expect the court if he has not disclosed the
20,000
incentive?
rupees.
Court has to presume that he is getting incentive.
Because my lord, we are assuming that he is getting more than 50,000. But
For assumptions on that, court will not, can't pass any order.
that is correct, my lord, because he was working from the 2015.
Counsel, please understand. We are on a legal issue.
Yes.
You cannot say what your client says.
Yes.
You have to argue based on what is the material.
At least as per the Honorable Supreme Court order, they have to disclose 3 years bank statement. That is not has been done in the trial court also. That's
He has disclosed.
where the my lord, that is page
page
number
number
50. That-
59, it is
That
disclosed.
is only monthly salary, income
Why
only.
did you not file your bank statement?
We will file it in the trial court itself.
Or not, we will file it. You should have
My
filed.
lord, kindly accept.
That's what is the judgment of the Supreme Court.
As per the direction of the trial court, we have filed.
No direction of the trial court. Supreme Court judgment. Basing on that, you are filing all this. So
Salary
Supreme Court
per-
judgment says
that
you have
he
to
has-
file all the things.
Monthly income of rupees salary, 20,000 rupees, he has been disclosed in details of income of the department.
Basing on what you did all this, basing on the judgment of Rashish versus Neha. What Rashish versus Neha says? That is unfair. The respondent shall place before this court the 3 years bank statements as per the judgment of the apex court in Rashish versus Neha. Serve the same on the counsel.
And also,
with
my
the-
lord, your lordship observed last date, 90,000 rupees arrears was there. Till date, they have not paid the 90,000.
Last time we have
What
paid
happened, my lord?
30,000 rupees.
Let's not
My
enlarge the
lord,
scope.
my lord,
of-
one more submission.
have paid.
Because last date 23/8/2025 appear before the trial court.
1,000
I
rupees
insisted
DD was
to
paid.
pay the 90,000 rupees arrears. But the counsel of the other side, they has forced to cross-examination the PW1. And I given your lordship judgment to not to proceed the matter, but they are not ready to.
You will, by giving a judgment, the court
Yes,
will not.
no, I filed the application 151
Not
also.
considered, come with an application.
That's
that
at least, my lord, the direction should be given to the pay the arrears of the maintenance amount, at least 5,000 rupees.
No, I'm not able to understand what all the arguments you are
No, my lord,
advancing. One say, you have come before the court for
Please,
seeking
please.
enhancement. Already there is an order by the
Yes,
trial court. Now I will pass another order to him.
No,
to pay the
at least your
arrears.
lordship is observed.
Why should the court do?
No.
Land counsel, please, Mr. Counsel. Land counsel for the respondent shall place before this court the 3 years bank statement of the respondent by serving it in advance to the counsel for the petitioner. List the matter on 23rd. Yes.
Please.
Say number 25. Suresh Babu, VN for petitioner.
AP for the petitioner. my lord.
Ramesh G.
Yes.
It's as against an order of giving the child to the interim custody of the husband. But this honorable court has made an interim arrangement while hearing the application.
that he should have the right of visitation, not taking the child. That was the interim order arrangement which was been made, and that has been continued on. And last occasion, your lordships has interacted with the child as well as the father and mother. And now today the matter is listed.
What has happened on the visitation? That has
The
happened?
visitation, it is continued, my lord.
Where is the counsel, Mr. Ganesh?
Ganesh ji,
What are your instructions?
Yes, ma'am.
How the visitation went on?
No, it is going on in the court premises. The
And is
visiting.
it going on well? What are the instructions, your client's instructions?
No, they say that sometimes he wants to, that child despite doesn't cooperate, he put pressure. That is normal wear and tear. I will not object, my lord. Let the father get acquainted with the child. That's what my respect is.
Earlier arrangement? No, I think this is, where is the order? No order is passed for the
But
visitation.
on the first hearing, when the matter had come up, my lord, such an interim order was passed, my lord, based on your lordship's previous order. So kindly take the order dated 30th December 2024. The coordinate bench of this honorable court,
Do that?
based on your lordship's judgment in WP number 19210 of 24.
What is the connection between that order and this case?
Lord, page number 82, my lord. Your lordships are earlier disposed of writ petition number 19210.
Hmm.
Lords may kindly come to page 85.
Hmm.
The father can exercise, may I read it later?
Hmm.
The father can
Between
exercise the
the same
visitation.
parties?
Please, my lord.
Between the same party?
Please, my lord.
Uh,
That your lordships disposed of the matter, my lord. Subsequently, they filed an application. And in that application also, my respectful submission was, let the father get acquainted with the child to take the interim custody. And that score, my lord, the coordinate bench has continued your lordship's order as an interim arrangement.
Where is this counsel? Doesn't even represent, I heard the counsel for the petitioner, no representation for the respondent. The interim arrangement made by the coordinate bench of this court shall continue.
Please.
List this matter in the month of November. Yes, 26.
for 26, Gurudat BS for petitioner, Hanuman Kayappa K for respondent.
To file an objection.
Yes, no objections in a writ petition are required.
My lord,
26, where is the interim order?
page number 27. my lord.
20?
The order 27, my lord.
Page number 28,
What is the order I number filed and
order from a memo.
The judgment letter and his wife has filed the present recovery.
consequences of the
in
execution
recovery
petition
total
filed with
amount
decree holder
so and so
against
from their
judgment letter for recovery.
The judgment letter in the affidavit accompanied of contending that our husband had filed a W and wife is a WC, seeking custody in the custody case her
Let's see the order, come to the reasoning part.
50% of the medical expenses. The materials are record out of the.
His writ petition, let him argue. Yes.
That is where I paid the entire amount, my lord. As on today, there is no arrears, my lord.
I think there is a
I will
procedure
file
in
a
the court.
detailed
Not
calculation of.
required. Let me look at it. If required, you can. Yes, argue.
My lord, first, there was an order in JNWC, my lord. 3 months, 3,000 rupees has to be paid in 2011 only. Till 2014, he was paying. After that, he never paid it. I filed an execution petition for that period. On the date of that execution period, I've asked for 1,08,000 rupees, my lord. Then this is a recurring cost. Every month you have to pay. He didn't pay it. Then I filed an order 6 rule 17 in the same execution petition that so much is due. That the court said that.
Before you argue, let's read the order. Before you argue, let us read the order.
Which order? Execution order.
Annexed D, kindly.
Impugned order.
Impugned order. Impugned order is, that is not correct. Why I said making a submission, my lord? Because.
Correct or not, we will decide later. First, we
No,
have to read the
no,
order.
my
Please
submission.
read the order.
My submission, my lord.
No submissions, first the order.
First, no memo of calculation is being filed by him. The order on memo of calculation is wrong.
I'll grant time for him to file his objections because you are not cooperating with the court.
Well, 1 second, I'm reading the order.
Read, I have to understand the case.
The
You know
decree-
your case.
I'll read my lord. The decree holder, the wife has filed the present recovery petition seeking recovery total amount of rupees 4,08,641 from her husband. The decree holder in the affidavit acknowledgement has contended that her husband has filed G&W seeking the custody.
No, which page you are reading?
The order, impugned order, my lord.
28 page,
Page
page number
number
28.
28.
Yes.
Execution 116/2023. And in the case on RIA, the court granted an interim maintenance of rupees 3,000 per month for the child and 50% of the medical and education expenses. The materials on record make out that the said GMP is being disposed on 1/7/2022. The order of maintenance passed on an interim order pending disposal of the petition. The decree holder has claimed the maintenance of 3,000 rupees from the month of 2015 to July 2023, total amount of rupees 2,76,000. The decree holder has also sought 50% of medical expenses from the month of November 2022 to July 2023. Since G&WC has been disposed on 1/7/22, the claim of decree holder seeking medical and expenses from 22 to 23 is not maintainable. The JD has furnished the memo of calculation. They are not done so, my lord. Then for payment of maintenance every month from 2015 to 2014, there is no balance that it has to be closed fully satisfied.
The present petition is hereby dismissed.
Where is that memo of calculation?
Which I have filed, my lord.
JDR.
JD has not filed, my lord. They has not filed in the trial court.
The JDR has furnished the memo of calculation.
That is wrong, my lord. Yes, they have not filed it.
Have you filed before the court?
He has not filed it.
Madam,
Sorry, my lord. Apologies, my lord.
Yes.
madam,
Have you
page
filed?
number 25.
Page number
20, I have filed, madam.
25. This is filed by whom? This is by the decree holder.
Annexure
Court
G,
is referring to-
C, madam, Annexure C.
Huh?
Annexure C, madam, along with the memo.
Registry is my execution petition, my lord.
If at all any arrears are dues, madam, let him file fresh execution.
I filed my fresh execution.
Without doing so,
Fresh,
madam, he
I
is
filed, my lord. Page number 32.
taking the same
What is the
proceedings.
statement? What is this observation of the court? The JDR has furnished the memo of calculation of payment of maintenance every month commencing from November 2015 to, so there is no balance. What is the basis for the court to come to such conclusion? Where is the calculation memo of yours?
I produced it in the, before the court also, madam.
Where is it? According to him, you have not filed.
Madam, the page number, madam. Page number. Annexure C kindly.
The registry is directed to call for
The
the
order.
lower court record. Whether the shall call for a report from the trial court, whether the JDR has furnished the memo of calculation. If it is furnished, the same shall be sent to this court. This is matter on,
On 2 weeks.
no 2 weeks. This is matter on 22nd of September.
22nd. 22nd.
Bill number 27. Ganesha B for petitioner. E. Ramesh.
This is the petition filed by the wife, respondent in the trial court. The husband has filed the petition for RCR, and I have filed the
Please come to the
application
impugned order.
under section 24.
Come to the impugned.
Yes, your lordship. Order is at
Page 11.
number. Annexure here, your honor. The
Yes.
important point to be discussed is
You're for the
I am for the
husband.
wife, your honor.
You're for the wife.
Petitioner, yes, writ petitioner.
You're seeking enhancement.
Order page number 12, your honor, and serial number 22. At the page 14, para number 14, it reads like this,
Pay
your
number
honor.
so and so is allowed in part, party petition to pay interim
Only
maintenance.
8,000 rupees awarded, your honor. Husband
What is
getting
the, what
30.
is, what is the income of the husband?
37,000. He is an employee.
Is a group D employee, madam.
Yes, yes.
37,000.
Yes, yes. My
Wife
My
and the
client
child
is
or
an-
only the wife?
Wife, yes, I'm representing wife.
Only wife or child is also there?
No, child is there. No. Even I have paid annulment of marriage, madam, Your Honor. There is no consummation. So the amount awarded is, though he is earning, having property, immovable property, he has given false statement in his assets and liability statement, Your Lordship. He has concealed his income. The Honorable Court has reiterated his in the para number 15. Though he accepts the RTC were produced, but he doesn't takes risk to award compensation maintenance to the wife.
What do you say?
My short passover, my lord.
According to our
Short passover. Senior is in quotal number 2.
This passover.
Serial number 28. Serial number 28. Devaki Adinath
I
Narayana.
appear for respondent, my lords. Your lordship, kindly grant a passover. My senior is arguing the matter in court hall number 6.
Passover.
My lords, if I request for it to be listed tomorrow, my lords, the arguing counsel, she is
Court has lot of work. Every day matters can't be adjourned. Yes.
List number list number 2.
Yes, Pradeep.
Serial number 1. B. Pradeep for appellant.
This case
On what ground?
Insurance company FP, on the ground that the compensation granted by the court below is on the
Look at the order sheet. What happened to their presence on the last occasion, respondent?
16,35,525 was granted, considering the disability at 90%.
Representation. Yes.
Considering the
Come to
disability.
the table.
That's what Malad.
Page number?
Table Malad.
No table?
It is there,
yes.
Malad. 40.
Yes. So let's calculate.
No, please, Malad. See, only problem is Malad, in 90% disability was taken on the memory loss, the ground that memory law. Petition has given the evidence.
But only on that point.
Yes.
Nothing
Only
else.
point, Malad, he himself is given the evidence before the court and adduce the evidence. When such being the case, Malad, the disability considered by the court below is on case. Injury issue number 4.
1 minute.
Para 23.
Yes, come to that issue.
The table. Injuries, Malad, 23 para.
About disability?
Disability is concerned 90% as per the doctor.
Same paragraph?
No, 34, Malad.
Yes, please read that paragraph.
Yes, SSD 34. Court has taken the disability as 37 para on the basis of clinical and radiological examination.
Let us see from 35.
Pardon me?
35.
Further stated, due to previous injury, petitioner following severe subjective defunctions of 90%, seizure 50%, the total disability calculated according to formula so and so. The formula was in support of chief has produced so and so. Psychological report is CT scan so and so. The case sheet. Even during the cross examination, he admit that even during the cross examination, PWS 2 has categorically stated that ನಾನು ಅರ್ಜಿದಾರರನ್ನು ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಆದ ನಂತರ ಪರೀಕ್ಷೆ ಮಾಡ್ತೀನಿ. ಈಸ್ ನಾಟ್ ಎ ಟ್ರೀಟೆಡ್ ಡಾಕ್ಟರ್. ಅಪಘಾತದ 2 ವರ್ಷಗಳ ನಂತರ ಅರ್ಜಿದಾರರು ನನ್ನ ಬಳಿ ಬಂದು 2 ವರ್ಷದ ಚಿಕಿತ್ಸೆ ಪಡೆದಿರುತ್ತಾರೆ. ದಿನಾಂಕ 12/10/2001 ನಾನು ಅರ್ಜಿದಾರನಿಗೆ ಮೊದಲ ಬಾರಿ ಚಿಕಿತ್ಸೆ ನೀಡ್ತೀನಿ. ಅರ್ಜಿದಾರ ಮೊದಲು ನಿಮ್ಹಾನ್ಸ್ ಆಸ್ಪತ್ರೆ, ನಂತರ ಮಂಡ್ಯ ಮೆಡಿಕಲ್, ತದನಂತರ JS ಆಸ್ಪತ್ರೆ ಚಿಕಿತ್ಸೆ ಪಡೆದು.
Appears to be some severe ailment only.
No, but when if that is the case, my lord, how the petition has given the evidence before the court? If I do agree, my lord, for 90% of disability, memory law,
No.
the petitioner has given the evidence before the court and admitted in the cross during the cross examination also.
If some person is not really all right, doesn't mean that all the time he'll be in the same state of mind.
What I'm mean to submit before your lordship, the disability considered by the tribunal is on this considering when the patient was.
According to you, how much it should be?
Your lordship can take 40% because they themselves has given the evidence.
We'll refer him to the medical board. Please, appears to be something, the element appears to be the insurance companies before this court. Please come. Only like, we'll keep it pending and we'll seek for a report.
Please speak.
Then
To
count the,
the Nimans Hospital.
the the insurance companies before this court questioning the disability, questioning the quantum of compensation. Then counsel submits that the court had considered the disability at 90%. 90%. It is submitted that the claimant had deposed before the court, and which shows that the ailments as stated by the disability as stated by the doctor is on the higher side. When this matter came up on the last occasion, there was no representation on behalf of the respondent. Again, today also, there is no representation. However, considering the evidence of the doctor and also the stand taken by the insurance company, the respondent claimant shall appear before the NIMHANS for assessing the disability on September 25th, and the doctors at NIMHANS shall assess the disability and send a report to the. Huh? No. Now medical board. That's why I said. No, there is no medical board. That will send him to the medical board. Why to NIM?
The person who was given the evidence is not from the.
No. We'll say he shall appear before the medical board. What is it called? Precise medical board, Bangalore, or what is that?
Nimans Hospital, medical board, Nimans Hospital.
It shall appear before the medical board, Nimhans Hospital, and after assessing the disability, a report shall be sent to the registry. Once a report is received, list this matter and inform the council also. No, not now. All that. Only matter is pending. Yes, next.
Serial number 2 urgent. Serial number 3. Serial number 3.
Give it that.
Reader.
On 5/6/2025, when this matter came up with the coordinate bench, there was no representation on behalf of the appellant. Again, on 22/7/2025, when the matter came up, the court has observed that despite the order, the appellant failed to furnish the requisites. Therefore, the stay granted is vacated. And then the coordinate bench has observed that in case requisites are not furnished within the time granted, office to list the matter on 11/9/2025 under the caption for dismissal. Today also, the office note shows that as on the needful is not done. Hence, the appeal is dismissed for non-prosecution.
Serial number 4. Upesh B.
Lordship, they have just now given the appeal memo, copy of the appeal memo. So I may kindly be given 1 week's time to file wakalat. It's a claim petition dismissed, Your Lordship.
We'll hear him. You can follow with all the experience. You people are appearing. You don't require time. Yes, argue the matter. Please use the mic. Yes.
The PW1 Millard, we say restrict lady Millard and puts her thumb impression. As stated that Millard, when a question was posed to her, whether the person who was riding the vehicle. Yes, she said she know. And another question was put, Millard, you implicated the vehicle. She said yes. Though she was not seeing the accident, Millard. And that is the one round. Literally, she put the thumb impression. It is there, Millard. She puts her thumb impression. A restrict lady.
Anybody,
and our mental condition is also.
Anybody will not say that have you implicated the vehicle is the question. She says, yes, we have implicated the vehicle. So something like
Nobody.
problem with their understanding.
Just now I
We'll
have
just read
received-
we'll just
Yes.
read it, and if necessary, we'll remand it.
Yes, Your Lordship.
Come to the
One
order.
one more submission, Your Lordship. I have not even filed wakalat, so whether I'll be authorized to argue this matter before Your Lordship is the. So I was requesting only for one
Ask-
day,
no,
till,
no.
at least till
No, no, no.
Monday.
Ask Pradeep, every day is arguing so many matters.
I think
This is a
Pradeep
New
was
India
Miller
Assurance
interested,
Company matter, Your
earlier
Lordship.
Pradeep was taken notice. And thereafter they.
Yes, file the wakal.
No, I have not
Then
filed
why
wakalat,
again
Your
another
Lordship. I
name?
don't know why. Probably he was directed to take notice and the company has not given wakalat or something of that sort, and thereafter I was directed. I only presume it, Your Lordship. I do not know what happened. If my brother Pradeep is ready to go ahead with that, I have no issues at all.
Yes, Pradeep?
No, my lordship express that matter is going to be remanded. Lordship may remand the matter and permit to file wakalat
Within 1 week?
Yes, Your Lordship.
Yes. Let's read the order. On what ground it is dismissed?
On the same ground. Millard, page number 16, Millard. The admission of PWL very clear that the two-wheeler bearing number so and so is falsely implicated in the case to get the compensation.
reading where?
from insurance company.
Paragraph?
Paragraph 11, Millard.
11.
By taking that admission, Millard, court has held that Millard, the admission of PW1 is very clear that the
He is the
two.
claimant.
She is the claimant, Millard.
Uh,
Wife of the deceased Millard. Death case, Millard. It's a death case, Millard. Regarding case.
Apart from that, we'll examine the other things also.
Yes, Millard. Millard,
When
then
did the
Millard,
accident taken place?
Millard, 22/1/2018, Millard.
At about 10:30 p.m.
Yes, Millard. Night. And complaint was given on 28/1/2018 when victim was died, and
Victim died when?
on 28/1/2018, Millard.
Oh.
On that day. Millard, immediately the accident, Millard.
This is one aspect, is 6 days delay. Then let's read the next para.
Next aspect, Millard, the medical record, Millard, that is the kept with you, Millard. It itself says, Millard, RTA, road traffic accident. That is there, Millard. They have only marked, Millard, exhibit P3 and P4.
TCR.
P3 is not marked by me, by you. P3, alva?
D.
We'll call for the TCR.
R3.
We'll call for the TCR. Other documents also we need to see. Admit, this is in what stage? Yes. Admit, post of final hearing, call for the TCR. List the matter after TCR is received. Yes.
Cell number for orders matter, cell number 5. Cell number 5, Prasanna, K.
Advocate for the claimant was submitted that the appellant is no more. They have given the details, my lord. I'm going to file the appeal applications for bringing of LRs.
5, you are not, 5.1 is there.
5.1.
Then counsel for the insurance company submits that as per his instructions, the petitioner counsel has informed, claimant's counsel has informed that the claimant is no more, and the insurance company will take appropriate steps. They also have to take.
They also have
to take steps. List this matter in the month of October.
Cell number 6. Cell number 6. DP.
Who is R2? R2 is who?
He is the owner of the vehicle, my lord. I am challenging the liability, my lord.
Then he has to be there.
And
Next steps.
Time default order.
Connected appeal also is there. 6687 of 22.
Where is that?
It
Has to be
not
listed.
been posted.
Oh, list along with so and so. In your appeal, owner is sir? Sir?
In that case, he has been directed to take notice.
No, owner is served in your case?
No, not
If
yet.
he is served, then you list along with so and so. Requisites within 1 week.
Cell number 7.
Default order.
Mahadeva
Yes.
Swami P.
Memo is filed seeking dispensation of notice to R1. Who is R2?
R1 is the owner of the vehicle, my lord.
2.
R2 is Liberty General Insurance. The
You appear,
Pradeep is
Pradeep?
directed.
Mr. Pradeep is
I
directed
have
to
served
take
the copy,
notice
ma'am.
on behalf of the
My lord,
respondent.
the case of death, only lots of consortium made matra.
If you give papers to him,
I have served the copies also.
Or shall we look at it? Only case of death, you can file wakalat within a week. Give that?
Tomorrow, my lord, I will.
Huh? Tomorrow. I'll list the matter. Not tomorrow, we'll have it on Monday. On Monday, print the name of Mr. Pradeep. And the council shall serve the copy of the appeal memo on the council. Yes, next.
Cell number 8.
Who is R6?
Right.
May not be necessary minutes. I'll argue on the merits.
Then can you file a memo?
I'll file.
A memo is filed seeking dispensation of notice to R6. Memo is taken on record and notice to R6 is dispensed with at the, oh, I think it is unclaimed. As per it should have been here. Why they have not putting the notice sent to R6 as per the postal share returned as unclaimed amounts to deemed service of notice. Yes. You are on what ground?
Minutes, on the ground of minutes, negligence and quantum. Not the.
First come to the negligence part.
Please. Minutes, we have not examined the any witness or even the official minutes. The injured minutes or the deceased minutes was walking on the road while the minutes offending vehicle minutes was taking in a reverse direction. He was taking minutes the reverse direction. That is 1 minute. Kindly see minutes. The paragraph number 9 minutes is the finding.
Please
Paragraph
read.
13 of the page 13 paragraph.
Please read.
In order to prove negligence act of the respondent vehicle, the respondent number 3, petitioner number 3 got examined himself as PW1 and filed his affidavit. So and so minutes on the last 8 lines. Exhibit P8 is the final report showing that the acquisition against the driver of the Mahindra vehicle. From these, it can be inferred that the deceased succumbed to the accident.
So whenever you say that there is contributory negligence, you have to do something that
we
you
have
have
not
not done. So
Not
then
done.
we'll leave that
Please,
point.
yes.
The next quantum.
Next point is that minutes, there are minutes 5 claimants.
Who are they?
Minutes, they are the widow and children, parents. 1/4 is deducted minutes. One of my ground is that minutes.
1/5.
1/4 minute. 1/4 is deducted. 1/3 ought to have been done. It is minute 1/4 is correct. There are 5 dependents. My contention is that the father would not be a dependent on the therefore minutes.
So what is the income? Which year is this?
Income is taken correctly. 14,000 is
So in
taken.
that case, loss of dependency, there is nothing to.
Nothing. Your lordship, can you dismiss my appeal?
In fact, if it is calculated, some more amount would be added with 5
Lordship,
dependents.
dismiss.
Yes, please come. Agreed with the award passed in embassy number 7016 of 2019, dated 3rd September 2021, whereby the court had, whereby the tribunal had granted compensation of an amount of rupees 23,95,000. The insurance company is before this court. The insurance company is before this court. Insurance company is before this court. Then counsel appearing for the insurance company submits that the accident has taken place while the driver of the offending vehicle is reversing the vehicle, and there is a contributory negligence on the part of the deceased. Secondly, instead of the court ought to have deducted 1/4, 1/3, but the court had deducted 1/4. On these 2 grounds, the insurance company is before this court. This court, the land counsel appearing for the respondent claimants that the court had rightly considered, and no evidence is adduced by the insurance company to show that there is contributory negligence on the part of the contributory negligence on the part of the deceased. It is submitted that when there are 5 claimants, 1/4 has to be deducted, and the court had rightly deducted the compensation. There are no grounds to interfere. Next, having got the counsels on either side, so and so. The first contention of the insurance company is with regard to the contributory negligence. The police, after a full-fledged investigation, has filed a charge sheet on the driver of the offending vehicle. The contention of the insurance company is with regard to the contributory negligence. If that is the case, when the material on record, as it points out at the guilt of the driver of the offending vehicle, and if the insurance company says that there is contributory negligence, they ought to have adduced necessary evidence. Admittedly, in this case, no evidence is adduced. In that view of the matter, the submission of the counsel for the insurance company cannot be appreciated. Next, the second contention is with regard to the compensation. The claimants are 5 in number. It is a contention that the father is not dependent. Without any evidence, this submission also cannot be considered. And the court had rightly deducted 1/4. And this court finds no reasons to interfere on that count also. Accordingly, this court finds no reasons to interfere. The well considered award passed by the tribunal. Accordingly, appeal of the insurance company is dismissed. Amount and deposit shall be forthwith transferred. Yes, next matter.
9. Pradeep B. for appellant.
Yes, Pradeep.
Girish KV.
R2 is the owner of the vehicle, my lord. I am challenging the liability, no permit as on the date of action.
No permit.
He is required, my lord. He has appeared before the MSCT.
To issue notice to he appeared.
Before
We have to
MSCT.
serve the notice on him.
Please, my lord.
A week's time, default order for
Number 10.
issuance of notice to R2 owner of the vehicle. Next 10.
10. Vijay Kumar
Fourth
T.
respondent.
Appellant.
Out and tomorrow, minutes we already discussed tomorrow.
What is that?
The 10th matter, I am the fourth respondent. Out and tomorrow, minutes.
Yes. Ms. Janardhan Reddy is directed to take notice for respondent number 4. What about 1 and 2?
1 and 2 are the one of the claimants. If for dispose of the matter,
The claim petition filed by the
compensation amount
parents,
can
my
be-
lordship. The claimants, the wife is the one of the claimants. She has made a respondent before the tribunal matter. I think their relationship is quarrel relationship. That's why.
But whatever they have to be, we
Somebody
have
has
to
to
take notice to 1 and 2. 1 and 2 have to be there before the court.
Yes, but wife is a respondent before the tribunal matter.
No. Is there any compensation awarded to R1, R2 and R4? R1 and R2?
Yes, my lordship.
Then they have to be before the court. The process shall be paid within a week as a respondent 1 and 2 is concerned, or its default order. Next 11.
Memo for dispensation to R3.
Yes, memo for dispensation of notice to R3. R3 is filed. Same is taken on record and notice to R3 is dispensed with the risk of appellant. Yes, 11.
Cell number 11. Hearing on interlocutory applications. Pradeep B. for appellant.
Appearing for the appeal.
B. promotes.
Why the TCR is required in this?
Please, ma'am. TCR is there, my lord.
Is there? Yes. Where is Mr. Pramod?
Pramod probably will come, my lord. Pass over.
Pass over. Yes, next.
Cell number 12. Number 12.
For the respondent, my lords,
for the
I have filed an IA for withdrawal of the amount, my lords.
We'll decide this. No withdrawal. Yes.
Please.
What is advocate is for the respondent in first petition?
I am for the respondent in first petition. my
R to Ramesh YN. No, where is the counsel's name?
Chitmallappa PM.
Siddhalip. Yes.
This is
Insurance company is on what ground?
We are challenging, my lords, the liability.
On the
because,
ground?
my lords, on the ground that, my lords, the insured vehicle is implicated. Insured vehicle is implicated. My lords, kindly see. The, my lords, MLC.
Give the TCR.
My lords, my senior will argue the matter, my lords.
No, we'll take care of your interest. Don't worry. If something we're going to pass any adverse orders, then we'll adjourn the matter. Please. I think they have to get the TCR pass over.
Yes.
My lords, kindly have it on Monday, my lords.
I already told you, if it is against any order to be passed against your client, then we'll adjourn.
Please, my lords.
That's according to me, my lords, there is no, the MLC, my lords, is registered on a tractor trailer, my lords. Number is also mentioned. In the, after 10 days, my lords, the complaint is filed against a different lorry. If, my lords, the lordships, he is seeking time, my lord, let it be adjourned to next week, my lords,
Yes.
so that they will have a defense, my lords.
This is matter next week.
Please,
Yes.
my lords.
Sorry for interruption.
No, yes. Third.
Even, my lord.
Yes, come. Yes.
Sorry, my lords.
Call 11.
11.
Lords, the respondent claimants have filed this application, my lords. There was an order passed by this honorable court permitting us to withdraw the amount in
We'll
deposit.
decide this.
Please.
Yes. Yes, Pradeep.
The appellant, insurance company is challenging the liability on the ground that, my lord, the deceased was riding the motorcycle without driving license and no policy, my lord. That vehicle, there is a
No.
head-on collision between
He's driving the vehicle without a driving license.
license and no policy to the said vehicle, my lord. I am the insurer of Tata pickup vehicle. There is an head-on collision between the two vehicles. The police, after thorough investigation, have filed a charge sheet against the deceased also, my lord, are the section 180, 181 and
No,
186.
if there is no policy to the vehicle, how you are not liable?
No, my lord, there is a head-on collision also, that's what.
Oh, that is the second aspect. No, as far as that submission of yours cannot be considered.
But police have charge sheeted, my lord, he
Charge
doesn't
sheeted
have
who?
license and no policy to the vehicle. He was playing on a public road, my lord, without having driving
License and all, no, that for the contributory negligence, we have to look at it. As far as your liability is concerned, you are on whether there is contributory negligence on the part.
Please, ma'am,
And his license and all will not absolve.
Some extent, my lord, he would also contributed to the alleged.
The charge sheet is filed against whom?
Charge sheet, my lord, accused number 1 is the driver of the Tata pickup.
Your vehicle. So, in every case where there is no driving license, is it a reason that looking at the accident, we have to see whether it is contributed or not?
Not only that, my lord, kindly see the spot measure and IME report.
Where the accident had happened, let's read it first, then we can see the documents.
Please. Exhibit P4 and P3.
No, first of all, we'll read and then this order where it is discussed with regard to.
Issue number 1.
Page 16, or internal page 9 of the order.
Internal
Yes.
page 10. Internal page 10, my lord. The motorcycle from Gudekote village towards Hirekhalli village, at the time Tata pickup vehicle which came from Hangal side and dashed against the motorcycle, of which Manjunath was sustained injuries and died on the spot. On the basis of the information given by the said Boraya, petition number 5 lodged
Is there or it has to be brought?
Exhibit P3 is the spot Panchanama, exhibit P4 is the MEA report indicating the damages of both the vehicles, and the IME opined that the accident was not due to the mechanical defects of the said vehicle. Exhibit P5 is the inquest report, exhibit P6 the postmortem report, and exhibit P7 charge sheet filed against the on Mallikarjuna GK, driver of the offending vehicle. On that basis, my lord, the charge sheet is filed against the accused number 1. The Mallikarjuna was a driver of the Tata pickup vehicle. On the basis of the police documents, the tribunal coming to the conclusion that there is a negligence against the driver of the Tata pickup vehicle. Next to that, my lord, the learned trial judge has discussed on that, my lord, and
Some judgments are already relied on.
delayed, my lord.
I've
And
consciously
that, my
gone
lord,
through
in
the
that, my lord,
decision
on
in
that judgment, 35% contributory negligence was
taken.
afterwards, my lord, further the discussion is that some other judgments also relayed. Para 13, which I relayed, my lord, that in that, my lord,
The
contributory
findings of the
negligence
High Court
quantified
of,
35%.
the finding of the High Court of contributory negligence on the ground that the deceased was driving the vehicle without a driving license is equally unsustainable. Driving without a valid driving license may expose the claimants to other liabilities, but no inference of contributory negligence can be arrived at on that basis.
Next to that, my lord, the tribunal had held that the rider of the
For now, we
motorcycle.
will look at where the accident had taken place.
Please.
That is marked as exhibit.
Exhibit, my lord, IME report may kindly be seen. Manner of accident, exhibit P4.
P4. Yes, motor vehicle accident report. Yes.
Light goods vehicle, my lord, that's a vehicle which is involved in the alleged accident in my vehicle. The motorcycle is that, my lord, the right side front mudguard dented and right side front bumper dented to the my vehicle, Tata SP. Front mudguard is broken, front headlight assembly is broken, front left right indicator assembly is broken. Right side of my vehicle, my lord, is damaged, my lord. He has come to the extent little right side, my lord, therefore it hasn't happened.
No, you're coming from this side.
Opposite direction only, my lord.
Correct. You're coming this.
both
No,
the
that's what I'm
damages.
saying. You're coming from this side. He's going from this side. Then why you why should we From that, how can you say that he was not careful?
No, both the vehicles, my lord, done collision.
Accident had taken
Front
place.
portion of the.
No, let's look at the sketch
not.
that shows
not
it is
produced.
on to the left side or to the right
Not
side.
produced, my lord. That's what, my lord, I'm submitting IMA report and smart master.
By basing on IMA report, we cannot say.
But they have not produced anything, my lord.
At least
How to substantiate
when you
that,
are
my lord,
saying
my lord,
that
at
there
least,
is
my lord, they
no,
would
no.
have examined the eyewitness, any of the eyewitness, my lord, to substantiate that, my lord, the deceased was no way responsible for the alleged accident, my lord.
No. At least if you say that there is a negligence on his part, the sketch would reveal
Sketch, they have-
exactly is the place of
They have
accident.
not produced the sketch, my lord.
No, you can also produce.
We have
Because you're
examined
relying
the
on
officer
that.
of the company by relying the charge sheet only, my lord, the police.
No,
has
along
charge
with
sheet.
that, all the documents will be there. When you're so particular that it is the negligence of the deceased, you would have produced that because that will cut the whole issue.
But they have also not produced, we also not produced.
So that is contributory negligence is no. Then what about the compensation?
Compensation, it requires for enhancement.
Let's see.
My lord, date of accident 11/12/2019, my lord.
1 minute. Where is the table?
Table. Table, my lord, internal page 18.
Yes. Accident taken place?
Accident
2019,
11/12/2019.
2019.
14,000 is there.
14,000. Age?
29 years.
Huh?
29 years. 17 multiplier.
It comes to 5,600. Married or unmarried?
Married.
Married, my lord.
How many are the dependents?
Five, my lord. Including mother, my lord. Wife, children and mother.
3 children,
Five.
my lords. 3 minor children.
4 is 4,900. That is 14,700 into 12 into 17. It comes to 29 lakhs 98,800. You said 5 are the dependents.
Please, please.
5 into.
Convenience led, my lord, consortium granted, my lord.
It's granted,
1
my
lakh.
lord.
How
Only
much is granted?
2 lakh, my lord. 2 lakh
It will
30,000.
be 2,20,000. 36,000, 10,000. It's coming to 32 lakhs 64,800 against 28 lakh 400. Tribunal has considered the income at
12,000.
12,000.
12,000 and multiplier and
Same,
future
17.
prospects all correct. Is agreed with about pass on MVC 38 of 2020. Dated 1st January 2022, whereby the court had granted compensation of an amount of rupees 28,400, held that the insurance company is liable to pay the compensation. Both the insurance company and the claimant are before this court. Insurance company's appeal is MFA 2209 of 2022, and the claimant's appeal is MFA number 6040 of 2022. In that, IA number 1 of 22 condone the delay of 70 days for the reasons stated condone. Then counsel appearing for the appellant insurance company submits that it is a head-on collision and the deceased was not having a valid driving license to drive the vehicle, and because because of that the accident had taken place and there is a contributory negligence on the part of the claimant. This aspect was not considered by the court. It is submitted that the insurance the as it is head-on collision, there ought to have been a 50% court ought to have apportioned the contributory negligence at 50%, on the claimant. It is on the deceased. It is submitted that as per the IMV report, the complete right side of the vehicle is damaged. This aspect was also not considered by the tribunal. Next para. Land counsel appearing for the claimant submits that this accident had taken place in the year 2019, but the court had taken the income at 12,000, which is on the lower side. On that count, the compensation needs to be enhanced. It is submitted that even on the conventional heads also, the amount that is awarded by the tribunal is not a just and reasonable compensation. Next para. First, having heard so and so. The first, coming to the submission of the insurance company with regard to the contributory negligence, the claimant, with regard to the contributory negligence, it is a case of the insurance company that there is contributory negligence on the part of the claimant, as he was not having a driving license and the right side of the vehicle is of the offending vehicle is damaged. No sketch is placed before the court. Basing on the IMV report, this court cannot come to the conclusion as whether at which side of the road accident had taken place, whether it is extreme right side to the offending vehicle or to the extreme right side of the deceased vehicle. If the insurance company is relying on that, it is the duty of the insurance company to place the sketch before the court, which was not placed. And mere not having a driving license, that itself cannot be a ground for this court to come to the conclusion that there is a contributory negligence on the part of the deceased. Hence, this court do not find any grounds to entertain the appeal filed by the insurance company. Next, coming to the appeal filed by the claimant seeking enhancement of the compensation, seeking enhancement of the compensation, the accident had taken place in the year 2019. As per the table, the notional income has to be taken at 14,000. As he's aged about 29 years, future prospects at 40% comes to 5,600. That is 19,600. As there are 5 claimants, 1/4 has to be deducted towards the personal expenses. That is 4,900. Then his contribution to the family would be 14,700 into 12 into 17 is 29,98,800. As there are 5 claimants towards consortium, 5 into 44, 2,20,000. Towards funeral expenses, 36,000. And the legal, in the light of the law laid down in Makel Houses, so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 32,64,800. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 28,400,000 to 32,64,800, and the appeal of the insurance company is dismissed. The amount and deposit shall be forthwith transferred to the tribunal. Yes, next.
Sale number 13.
Much obliged.
For appellant, your lordship, subsequent application has been filed for substitute service.
Where?
As for substitute service for paper publication.
1 minute. In
In
13.
Yes, ma'am.
Huh.
to R1
I
and
number 1
R3.
of 25 is filed. The substitute service of notice on to R1 to R3. Oh, yes, by way of paper publication, permitted to so and so. Look at it. Then coming to 13.1, the notice to R1 and R2 as per the postal shara returned as unclaimed amounts to deemed service of notice. Then
Furnishing of PF.
for issuance of notice to R8, a week's time, default order. Yes, next.
That is draft 25.
Then 13.2.
Cell number 33.2.
Then nothing.
Awaiting
13.
service. Step to the
This also 13.2. The council shall come up with appropriate application for substituted service, or else the appeal shall stand dismissed within 15 days, or else the appeal shall stand dismissed without further reference. Yes, come.
Cell
Come to the
number
next.
14.
Obliged, your lordship.
Cell
Yes.
number 14.
Appear for respondent number 1.
Serial number 14, my lord, the advocate, tomorrow, morning I have mentioned, my lord, the advocate is suffering from ill health, my lord. Kindly grant me 1 minute.
Not tell, it seems. I number 1 of 22 is filed to condone the delay of 74 days. Condone. Who moved the memo?
I moved the memo, my lord. This
He's
is the, my
seeking
lord.
adjournment, that's why.
Please.
When do you want?
Next week, any date, my lord.
Tomorrow?
Day after tomorrow, Monday, my lord. Tomorrow, he is suffering from ill health, my lord. The advocate on record.
Someday.
24.
Like a look at court time also should permit every matter. Yes, next.
Bill number 15,
For the
A. Ravi Shankar.
announcement, my lord, in the last occasion, your lordship directed me to produce the proper citations, my lord. Par number 15 of the Birendra judgment and also Simarani's, it holds good for me, my lord. It may be taken into consideration, my lord. Major sons are eligible.
My lord, if I were to distinguish the Seema case, in this case, in that case, the claimant who were declared as the dependents, they were earning less than 1.5 lakh per annum, and the other claimant was a part-time worker. In this case, my lord, both the sons, one is a school teacher and the other one works in the police department.
That is there on evidence. Evidence is there on record.
Yes, ma'am. It is their PW1 and they're 54 years old.
In Birendra's case, my lord, par number 15, it says that major sons are also eligible, my lord. Those
No, you cannot be called a dependent at all. Because when you're working you're on a government job, how can you be dependent on the deceased father? At best, you'll get as per Mano Valgan's case, whatever that amount that you can get.
in that regard, par number 15 of the Birendra judgment.
That, please, because looking at your occupation, how can you be, please look at both the judgments, then we'll pass an order. List this matter next week. Yes.
Bill number 16,
Blessed.
Waiting for the rest.
Two more
Case launch.
appeal is there, my lord.
J. Kumar T.
What is that?
We have, company has filed two more
Company has
appeals,
filed.
361.
List along with so-and-so next week, next 17.
My lord,
Delay
Delay of 83 days may kindly be, maybe delay of 83 days in today's. appeal
I
may be
number 1 of
condoned here.
23 is filed to condone the delay of 83 days, condone.
and trial court or record may be called for, my lord. They are challenging.
Then
the-
admit post of file hearing, call for the DCR.
Please.
Next.
Bill number 17,
Respondent number 4 in this matter.
Appear for appellant.
Seeking enhancement.
Yes, ma'am. Liability and enhancement, madam.
Liability is on.
Liability and no driving license, fixing liability owner of the vehicle.
One more petition was there. In that petition, tribunal has fixed the liability of insurance company, but in present, tribunal has fixed the liability
On the insurance company. No, please, ma'am.
They have satisfied the amount in that.
No, in that pay and recovery is ordered.
No, my lord.
Completely. So then.
In this also company is only liable, my lord. As per issue number
Cholamandalam
2.
Insurance Company served unrepresented. There are two vehicles.
Two insurance company. One is ICICI and another one is Cholamandalam, my lord.
No, he says we are on the liability.
No, my lord. As per
I am for
the
the.
para 17 of
claimant.
the judgment, my lord. Para 16, it is clearly
Mandla,
stated.
who appears?
B. Pradeep appear for second. Cholam.
Where is Mr. Pradeep? Give him the papers. Afternoon we'll take. Mr. B. Pradeep is directed to take notice on behalf of Cholamandalam.
R2.
R3. Pass over. This 18.
Bill number 18, Pes Dabali, the appellant.
Appeal by corporation for case of death of a bachelor. I have filed the appeal matter on the point of negligence. In connected matter, it is a case of death matter. This is was the inmate of the car. When the claim petition filed by the driver, 50% has been opposed matter, contributed negligence. Under those circumstances, I have filed the application to impede the owner and issuer of the car matter in this appeal. The notice has to be issued matter.
Notice on all IAs.
I number 2, only I number 2, matter. Proposed respond number.
Oh, I number 2. Notice on I number.
Proposed respond number 2 and 3.
Financial crisis. I would like to address the argument. Because only
We have
30,000 has been released. And he is not
My lord, I appear for the respond, my lord, 1 and 2. My lord, they have deposited the 50% of the award amount, my lord. My lord, kindly TCR may be sent back the tribunal, my lord, release the award amount, my lord.
The interim order has stay has to be granted, madam. Only stay was not granted.
Why will we grant stay in 2023 for a petition?
2019.
Now they have filed not attachment warrant, but
They would file.
we already paid 50% of the award amount. They may be granted, but they may be permitted to withdraw the said amount.
2019, my lord, 50%.
So we'll say that 50% there shall be stay. on the 50 pages.
Deposited amount
We are
computed
departing,
to
my lord,
the
50.
withdrawal, my lord.
The IN number
Four.
1 of 23 is filed to condone the delay of 123 days in filing. For the reason stated, the delay is condoned. IN number 4 of 23 is filed seeking stay. It is submitted that already they have deposited 50% of the amount. Accordingly, they shall be IN number 4 of 23 is allowed. The land counsel, the respondent submits that they may permitted to withdraw. The respondents are permitted to withdraw the deposited amount. The registry directors and the TCR. For once the amount is withdrawn, same shall be sent back. Yes,
Kindly return the TCR, my lord.
that's what I said.
Please,
Notice, my lord, I number 2, my lord, for
IN
increase.
number 2, notice.
Proposed response, my lord,
Yes.
3 and 4.
my lord, one more submission, my lord. Kindly post along with connected MFA, my lord.
Take that a list along with so and so.
5029 of 2023,
Yes.
5014 of
19.
2020. Much of it.
Number 19, D. Vijay Kumar.
For the appellant, my lord, I have filed the IF for releasing of the deposited amount, my lord.
Where is he? Tell him password.
Please, my lord.
For admission matter, cell number 20.
Paper the appellant, man. Appeal by owner, my lord, in this case.
For the appellant in connected matter, my lord. Connected matter, my lord, is for claimant appeal for enhancement. My lord, first appeal is preferred by the owner of the offending.
What is saying?
But before the tribunal, my lord, he has not produced any evidence. He has not produced.
You know, that we will see now.
Please, ma'am.
Yes.
I don't think I have any case, my lord, to be frank. I have
Now
challenged.
we'll straight away go to his enhancement. Yes. 20.1. Something is wrong with this. Yes, 20.1. Where is the table?
Table that it's only quant.
I'm asking him. Where is the table?
Table.
Yes, come to.
Page number, my lord.
Internal
Yes.
side 18 and 19.
Yes, yes.
Page number 19, my lord.
Yes. What are the injuries?
Lord, injuries, my lord. Page number 9, my lord. 9 of the judgment.
Yes.
Bottom. Complete tear of
Complete
anterior.
tear of anterior sciate ligament with tear of both arms of lateral meniscal of the right knee joint. Dislocation of right knee joint. How much the court had granted?
Not towards
Yes, another we grant another 10,000. Yes.
No
How many
insurance,
days at the hospital?
I think.
31
Whatever
days I was admitted to the hospital, my lord. 31 days.
Whatever granted is just reasonable since no insurance is.
Next is it was attended at 30.
31 days in different dates, my lord.
31,000.
And underwent surgery also.
Medical expenses as it is.
Please, my lord.
1,22,358. Then which year is the accident?
2015, my lord. Tribunal has
According
taken.
to you, how much you're earning?
My lord.
According to you,
Please, my lord.
how much you're earning?
He was a retired HL employee.
25,000 by doing agricultural.
Court had taken 11,000.
Please. Please, my lord.
Court had taken
7,000.
Court has taken 7,000.
7,000. Which year is the accident?
2015, 9,000 has to be taken.
He was a retired employee.
And disability tribunal has taken correctly, my lord. 21% tribunal has taken.
How much was taken disability?
21%. Doctor has assessed 61.
The disability. So then.
Multiplier 7, my lord. At the time
One
of
minute, 1 minute. Income is 9,000.
9,000.
So 9,000 into 12 into what is the multiplier?
7, my lord. 65 years.
7 into 21.
21.
It's coming to 1,58,760. Amenities, another 10,000. Future medical expenses, what is the evidence of the doctor?
No, regarding that, my lord,
Criminal rightly awarded 20,000.
Yes, will not.
20,000 is awarded, my lord.
Legal expenses, 10,000. It's coming to 4,49,118 against 3,66,838.
Lord, towards a laid up period, my lord.
20 27,000.
21,000 granted.
Please come. Agreed with the award passed in MDC number 996 of 2016, dated 8 March 2019. Both the owner of the vehicle as well as the insurance company, as well as the claimant are before this court. Owner's appeal is MFA number 6715 of 2019, and the claimant's appeal is MFA number 2201 of 2020. In his appeal, claimant's appeal, IA number 1020 is filed to condone the delay of 226 days in filing. For the reasons stated, the delay is condoned on the condition that is not entitled for interest. The claim petition is filed seeking compensation of an amount of rupees 5 lakhs for the injuries sustained in the accident. The court had on the liability has held that. Where do you get the liability?
Liability, I should get it.
That the vehicle in question is not insured with is not having a insurance policy. Hence, the owner of the vehicle is liable to pay the compensation. And when it comes to the compensation, the court had granted the compensation as per the table given below. Internal page 18, it is there. Land counsel appearing for the owner of the vehicle submits that the court, without considering the evidence on record, had granted an amount of rupees 1,22,358. It is without any basis. The court had taken the disability at 20%. 20, what is that?
21%.
1% is on the higher side. The court ought not to have taken 7,000 as the income. It is submitted that on all counts, the compensation that is awarded by the tribunal is on the higher side. Land counsel appearing with the respondent submits that the accident had taken place in the year 2015. Court ought to have taken 9,000 as income. Further, it is submitted that once the court had rightly taken 21% as the disability, and on all counts, the compensation needs to be enhanced. Next part, having got the counsels on either side, peruse the material on record. The accident has taken place in the year 2015. The court ought to have taken the income at 9,000, considering the meniscal tear and the dislocation of the knee. This court is inclined to grant an amount of rupees 50,000 at the head of pain and suffering. Attendant charges, considering the 31 days of hospitalization, this court is granting 31,000. Medical expenses, this court has perused the order and the court had rightly granted and no interference is called for. Coming to the loss of income during the later period, 9,000 into 3, 27,000. Loss of income due to permanent disability, court had rightly taken the disability at 21% as per the evidence of the doctor. 9,000 into 12 into 7 into 21 by 100 is 1,58,760. For the loss of amenities, considering the disability of 20%, this court is granting 30,000. future medical expenses. Court has already granted 20,000 and no interference is called for. But then to the legal expenses, the claimant is entitled for an amount of 10,000. Altogether, the claimant is entitled for an amount of rupees 4,49,118. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 3,66,838 to 4,49,118. The enhanced amount shall carry 6% interest. The amount, the appeal filed with the owner of the vehicle is dismissed. The amount in deposit shall be forthwith transferred to the court.
Applies.
It's already condoned, I told her. Yes.
Then number 21. 21, Mallikarjun.
Let the
Who
case,
appears for the respondent?
B. Ramakrishna, my lord.
Inform him or we take it next week?
Next week, my
Mrs. Marta next week. Is 22.
Then number 22.
Gurdev Prasad.
Then
Yes.
Prasad.
Who appears for the respondent?
It is Judge
Jalakumar.
Kumar.
Jalakumar.
Hmm.
Jalakumar. Only for enhancement.
No, that's what you want. You will inform him or shall I adjourn this matter?
No, I will inform him. You may come.
Afternoon.
Then number 23. Gurdev Prasad. Same.
Ready, Vijay Kumar.
23.
Yes.
Kohani.
Yes, sir.
Bolla for appellant.
ಈ ಕಡೆ ಬರ್ತೀರಿ ಈ ಕಡೆ ಬರ್ತೀರಿ
You are on what ground?
I have filed this appeal, questioning the liability as well as the quantum, your lordship.
Liability
As
on
far
what
as
ground?
liability is concerned, there is exhibit P6 and P7 to motor vehicle accident report, which says that the bus, there is no damage caused to the bus. So it is our case that at this signal at Patrahalli on KR Road, so this, after the green signal was lit, the bus moved, and at that time, the motorcycle
Then
rider.
we'll continue this matter after 2:30 matters.
2:30. Yes, sir.
Yes. Get it? Signature.
Lord, on submission, Lord, serial number 5.
No mentions now. My lords, no mentions now.
I'm not seeking adjournment.
My lords, my apologies, serial 23, I could not be there. I'm extremely sorry, my apologies, my lords. I had moved a memo and it was urgent. May I take
Because the
chance?
difficulty of the court is you see the list. There are about another 40, 50 matters to be.
It's my this thing. Plus, may I move a memo at least before the vacation?
Yes.
Great.
ಅದು ಬರಿಬೇಕು ರಾವಿಷದಲ್ಲಿ ಅಂತ ಇದೆ ರಾವಿಷನ್ ಕೊಡಲ್ಲ ಏನಿದೆ ಯಾವುದು 23 8:10 ಅಲ್ಲ 2:30 we should complete continue at 2:30 ಇಂದಿದ್ದು 2:30 23. It is there, 23. List 2, 23. List 1, 23 you are telling. List 1, 23. It is on 8:10. 8:10. Ade. That only. It is there, ಅದು 8:10 ಅವ್ರಿಗೆ ಕೊಡ್ತಿದ್ದು. Liberty to move ahead to court ಬರಿಬೇಕಾದ್ರೆ ಇವತ್ತು ಹೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಇದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇರೋ ಡೇಟ್ ತಗೊಂಡಪ್ಪ ಇನ್ನೊಂದು ಯಾವ್ದೋ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರಲ್ಲ ಮೇಘಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ serial number 21 24 20 22 there are already 28 matters so 22 23 24 right on 24 9 21 also on 24 9 And 22 is Passover. 23 is also 15. 15 also you want date, Allah? And 24/9. Because on that day only there are less matters. Huh? 21. Not just half. 20.
ಆಯ್ತು ನಾಳೆ
ಇವ್ರನ್ನ ಇಬ್ರನ್ನ ವಾಪಸ್ ಕರ್ಕೊಂಡ್ಬಿಟ್ರಾ ಅವ್ರಿಬ್ರು ಇನ್ಯಾವುದೂ ಇಲ್ಲ 19 ಅಷ್ಟೇ ಯಾಕಮ್ಮ ಹೋಗ್ಬಿಟ್ಟು ಹೋಗು 2 ನಿಮಿಷ ನಿಧಾನಕ್ಕೆ ಊಟ ಮಾಡೋದಾಯ್ತು ಕೊಟ್ಬಿಡು
Is number 5.
I'm for petitioner in this case, my lord.
Yes. Yes, Pradeep. You're ready for that? Where is the council?
I'm for the petitioner in this case, my lord.
They say that they are ready for another 30,000 lump sum.
My lord, at least they may consider for 50,000, my lord. Assess, conveyor itself assessed at extent of rupees
No,
2,00,000.
now he says 40,000. Then counsel for the insurance company submits that they are ready to pay an amount of 40,000 globally. The party shall file a memo before the Lok Adalat on Friday. Yes, next.
Cell number 2.
My lordship, I'm for the respondent number 3, my lordship. Settlement is not possible, my lordship. It's a
Delete
contributing.
this. List is marked in the usual course. Yes, read.
Much obliged, my lordship.
Yes, Anup Sitaramaro.
Anup Sitaram Rao, Shamir Ahmed.
That is mine.
You have any discussion with him?
Yesterday discussed, my lord.
How much?
No, he's telling he has to discuss the company. Maybe they will agree or they will not agree. He said like that.
What is that?
Yes.
Hmm.
Some medical bills are there. They have not considered by the trial court, my lord. That I have submitted yesterday.
Anup Sitaram Rao, leader and order.
Record is there? Lower court record?
No.
It's not
That is
possible.
not
Then we'll call for the
possible.
record. How much? 40? 2 lakh. This one, list is, registry is directed to call for the TCR. List is matter once the TCR is received.
Yes, my lord.
Next 4.
Cell number 4. Pradeep B.
This has to go before the revision bench. It is submitted that the claimants have preferred an appeal and the same is pending before the division bench. List along with, you have a number?
That number is there.
List along with so and so. Yes, next. 5.
Cell number 5.
Lords, for the appellant, my lords, I pay some short accommodation, my lords. My
Yesterday
senior
they were
is
there.
not well, my
Where
lord.
is Shivanagoda?
Is Shivane Gouda?
He is discussing with before case. Sir. Ask him to come.
My lords, my senior is
One
not
minute,
well, my
one
lords.
minute.
Short accommodation.
What happened to this?
Yesterday.
5. Who are they? Is there any connection between the injury and the? Hmm.
That's one. Lords, I am not aware of the facts of the case, my lord. I can't take that.
Where is he?
He's not keeping well, my lords, from yesterday. It may be taken up tomorrow.
Tomorrow.
Yes, ma'am.
Tell his proposal that
Obliged.
above and all another 20,000 they are ready to pay. Yes.
Obliged.
Next tomorrow.
Which number 6? Cell number 1 for orders awaiting DCR.
Dispense with. Yes.
Test Gouda.
Have you informed him? ECA matter. Yes, list is matter after the TCR is received. Next.
Cell number 2 for admission.
What about this Ravi Samprati?
Chair Rajagopal, Ravi Samprati.
No, but
Ravi Samprati for respondent.
admit post of final hearing. Call for the TCR.
Cell number
Next
3.
3. What about this?
Pavan Chandra Shetty.
I gave a proposal, my lord. They'll said, my lord, they'll get to know on.
What is your proposal?
My lord, 1,000 maybe, my lord, notional income 11,000 was taken by the tribunal, my lord. He was working, my lord, in the.
Oh, with regard to skilled and unskilled.
Natural ice cream.
Tomorrow? Tomorrow.
Please, my lord.
Then number 6.
If they agree, Pradeep, if they agree, if I come up with a joint memo tomorrow.
Then number 4.
Anyway, I'll say refer it to the Lokadal. I mean, to the. It is submitted that. If you don't file, it's fine. Parties submit that. They're negotiating on that, and they'll file a joint memo. Let's just matter with the Lokadal tomorrow.
Then number 4. Then number 4.
What about this?
Raju, yes.
They're not. Tomorrow.
Then number 5.
Regarding of no, they have taken notional income, Your Honor, instead of income tax returns.
Pradeep,
Sir.
what do you say about this? There is evidence on record about his income.
Yes.
What is the evidence?
Income tax returns, I filed it, Your Honor. And medical. No, this is exhibit.
No, you are seeking loss of future income.
Yes.
And the income tax returns which you have filed
Yes.
shows that you are continuing and your income has increased.
No, that one I have to take information, Your Honor.
So,
And
in
also,
that case,
yes.
what we can do is, under the head of loss of amenities, you can grant some.
No.
How much is granted?
No, in that, the medical, the doctor has given a 30% of disability. Now they are taken 15%, and also the loss of another ground that loss of
I think
within the
discuss with them. If there is possibility, we can.
Definitely.
It is submitted that the parties are negotiating, and there may be there is a likelihood of settlement. This is matter before the Lok Adalat
tomorrow.
Tomorrow, all these matters at 1 o'clock. All the matters wherever I'm saying Lok Adalat, 1 o'clock.
Cell number 6. Guru Prasad BR.
My lords, I'm for the appellant. In this matter, my lords, what has happened is the wife and children of the deceased have filed one claim petition, and mother and sister of the deceased have filed another claim petition. Both came to be clubbed, and judgment came to be passed, my lords. However, two different awards have been passed. 50% has been apportioned, my lords. The mother and the sister of the deceased have preferred an appeal prior to this appeal, and they got settled the matter, and they have the insurance company also, without verifying two case numbers, my lords.
Entire amount is paid.
They have not deposited as per my knowledge is concerned.
Where is that case?
Kept below is, my lords.
7010. No, you mean
because I am entitled for 50% of the as per the tribunal.
But
thing.
the order is about 100%.
That I am not aware because
No, it is here.
I have not filed my wakalat in that matter, my lords. Before filing of my wakalat, my lords, they got it settled before the Lok Adalat, and they went
What
away.
it says, what is the amount?
My lords,
Entire amount that is granted.
in total amount, my lords, 17 lakh 2,000.
17 lakhs.
2,000 has been total award.
Half of the.
Out of not exact of my lords, in the loss of dependency 50%, and my lords, so wife and 3 children were there, 2 children.
So, what is your entitlement?
Well, it's 50% because so far as the other heads are concerned, okay. So far as loss of dependency, 50% enhancement I am entitled. Loss of dependency.
As far as this matter is concerned, the order of the Lok Adalat is.
All the problem is that 2 different case numbers are there. For that reason, they have also not verified, and I think they have agreed.
It is ordered and declared that the appellant claimants have agreed to receive a lump sum of 2 lakh.
Please, madam.
In
So far
addition
as,
to what has been awarded by the tribunal.
that is in so far as 419 as for 2015 is concerned.
Let's see. Give the
Please,
file.
madam.
Let us see the award.
That is, my lords, so far as MVC number 419 by 2000.
You are ready for the 2 lakhs for the entire one.
That is not forthcoming. That is not being reflected.
Still for the entire amount or their 50%? It would be their 50%. Huh? How can it be 2,000? But then how can it be? Who's the counsel up here?
Pavan Chandra Shetty.
Print the name of Pavan Chandra Shetty. List this matter tomorrow.
List number 7 for order CL number 1. Retirement.
Memo of retire. Let's see what is that.
Correspondent.
Where is the memo? No representation. This is matter in the month of December. Next.
Cell number 2.
Next, in 2, memo is filed seeking dispensation of notice to R1. Dispense with. Yes, where is Mr. Dabali?
FS Dabali.
She is appearing for the. I think she is appearing for. You appear for the case RTC. In list number 7, have a look at. You can come this side, I think.
Number 7, serial number 2.
In list, you have the list? Cause list. List number 7, item number 2, MFA 4052. You are ready for land counsel for the insurance company submit the case submits that they are ready to pay an amount of rupees 25,000 globally in addition to what has been awarded by the tribunal. List this matter tomorrow before the Lok Adalat. Please inform Mr. Chetan also. Tell your advocates. IA number 1 of in this 2, IA number 1 of 21 is filed to condone the delay of 84 days. Condone. Yes, next 3. 1 also, but in this matter, some memo of retirement is filed. Oh, he's already there. In one, how many? What is the amount? 25,000 globally in addition to what has been. Yes, next.
Serial number 3.
What about 3?
For the appellant in this case, case of injury. Respondent is
So for the insurance company?
No, KSRTC matter.
KSRTC. Who takes notice? Who is the counsel for? Mr. FS Zabali is directed to take notice on behalf of the insurance company. What about this?
Injury case. Tomorrow, Malata calculation.
No, have you calculated? That's what.
Yes, ma'am. Please, ma'am.
You please.
Please.
Yes.
Please.
Then what will they like? It is submitted. Same negotiations going. Tomorrow they'll file a joint memo.
Please.
Yes. Next 4.
For 4. Serial number 4.
Memo is filed seeking dispensation of notice to R1 dispensation at the risk of harm.
Veerabhadra Swami. HR Renuka.
No, what is your proposal that you can tell? With interest. It is submitted that in addition to what has been awarded, they are ready to pay 2,80,000 with interest at 6%. This also for joint memo. How much is delay?
Delay.
There is no delay. Delay is there?
Delay of 370 days.
IA number. It is already condoned on condition.
Not condoned.
Then you will see. IA number. One of 23. IA number 1 of 23 is filed to condone the delay of 317 days. No objections are filed. For the reasons stated, delay is condoned. However, on the condition that they will not be entitled for interest for a period of 317 days. Yes, next. What about 5? 5? No. What is that they're ready
Team
to?
Ayesha,
5.
United India.
35? Same 35,000, 6% joint memo tomorrow. Yes, 6?
There is delay of 1,400.
I am for the respondent.
What is that?
1,200.
Delay is there. I number 1 or 20 is filed to condone the delay of so and so on condition that they are not entitled for interest for the set period. Yes, next 6.
Till number 6.
Lord, I appear for second respondent in this case, my lord. That
This also, I number 1.
Previously, it was ordered on merits, my lord. It has been decided on merits. I don't know why they have filed again. It is a company had preferred an appeal, and claimant had also preferred an appeal, and it was disposed. Both were dismissed on merits itself.
Where? What is that order and what is that number?
Company appeal is 7483 of 2013. And claimant's appeal is 4359 of 2014.
When are they disposed of?
They were disposed of on 28/1/2016.
Registry is directed to place order copies in 7483 of 2013 and 4359 of 2014. This is matter tomorrow. Yes, next 7.
Till number 7. 7. Shivaprasadyam. Shivaprasadyam. Raju Shekhar S. 70,006%.
70,000, 6%. Yes, 2 days. IA number 1 of 23 is filed to condone the delay of 2 days. Condone. Yes. Next.
Serial number 8. Pawan Kumar.
There is delay of, my lord,
How much?
920.
921 days delay.
That we will impose on condition. I number 1 of 23 is filed to condone the delay of 921. Same on condition. Yes.
Yeah.
8 lakhs with interest.
8 lakhs?
With interest.
Yes, 8 lakhs, interest of 6%. Yes, all these matters are coming up tomorrow at 1 p.m. in the Lok Adalat. Yes.
Till number 9. Swami.
What about 9?
9.
Next in this,
With interest. 80,000 with interest.
80,000, 80,000 with interest at 6%. IA number 1 of 23 is filed to condone the delay of 88 days. Condone. Next 10.
Number 10. Till number 10. Tantra
If you're agreeable, we'll see. What is the amount?
4.
Huh?
40,000 with interest.
What do you say?
I'm not.
Less is matter in the usual course.
Delay.
Yes, IA number 1 of 23 is filed to condone the delay of 27 days. Condone. Yes, next 11.
Number 11. Rupesh B. Radha BP.
What about this?
4,79,006%.
4 lakh 70?
9,000.
Yes, 6%. Next.
Till number 12. 12. Mahadeva Swami P. 12. Mahadeva Swami P.
Yes,
89,000.
89,000 with interest. 89,000 with interest 6%.
Till number 13. Till number 13. Syed Abdul Pat. Akbar Pasha. BP Raja.
This will list this matter in the usual course. Yes.
Serial number
14.
14,
163A.
Sandesh Shetty.
163A, my lordship, maybe that. 163A. 1 lakh.
1 lakh 68,000.
1 lakh 38,000 was awarded.
Hmm.
It may not be, it may be posted before the.
Yes, usual course.
It's a case of injury and 163A claim.
No. Yes, next.
Serial number 15, Chantraj K. 15.
What about this?
IFA for the respondent case or disseminate.
K. Nagaraj.
Amount?
IFA. Amount.
Is here any amount? Hmm.
Husband, mother-in-law and parents are payment.
Hmm.
She proposed 3,82,400 with 6% as additional.
3,82,000.
82,400 as additional.
You are agreeable or we?
I am not agreeable.
Yes. The list is in the usual course.
Serial number 16.
16 IFA for the respondent case or another 15,000.
Huh?
Another 15.
Another?
15.
Sir is telling another 15,000, my lord, plus interest. Okay, ma'am.
15 global.
15,000.
global maybe okay.
Huh?
20 global.
No, 15,000 lump sum. 15,000 lump sum because in the connected matter, with respect to paying
It is
into
obvious that the respondents are ready to pay an amount of rupees 15,000 globally, and both the parties will file a joint memo tomorrow.
Please.
Before the local adalat is tomorrow. Yes, 17.
17.
My lord, it is appeal, my lord, with regard to the negligence of the motorcycle rider. So we'll argue that later.
I mean, I'll list this matter in the usual course.
Serial number 18.
Much obliged.
18, Chantraj K.
What about this?
Death of both husband and wife, my lord, elder brothers of the major brothers aged about more than 50 years.
So you're on that point. Yes, this also.
Usual course. Serial number 19.
19.
Serial number 19. Tejas N.
What about this?
Sundara Swami.
Another 20,000 because she was a teacher and there is no much
20,000
serious.
with interest or globally?
20,000 plus interest.
Not agreeable.
This is matter in the usual course.
Serial number 20.
55,000
Syed
global.
Abdul Sabur.
55,000 global.
50?
55,000. With 6% interest. I'm sorry.
55,000, 6% interest tomorrow. Yes, 21. Please inform the other side also so that they'll come tomorrow.
29. Serial number 21.
21.
21.
3,22,000 with interest.
Not agreeable, my lord.
So yes, this also.
Usual course.
Yes,
Serial
usual
number
course.
22. Ravi Shankar Shastri. 22. Ravi Shankar Shastri.
What about this? Inform him. 44,000. Joint memo for tomorrow. Yes, next 23.
Serial number 23. 23. Pavan TG.
What about this? Twenty-three. MFA 425.
425 of 23.
Last one. Passover. Yes. Continue. Call the Passover.
Passover. English number 1, serial number 27. List number 1, serial number 27.
Responding.
Yes.
I am seeking enhancement of maintenance awarded to the wife, Your Honor. It is the respondent.
Yes, yes, Mr.
My lords, kindly refer to the allegations made by the petitioner, my lords, petitioner hearing. My lords, marriage is on 23/9/2024.
separation is from 5/1/2024. My lords, that is only,
How can it be?
oh, sorry, my lord, 3/23, my lords, 3/9/23.
3/9/23 is the marriage.
Yes, my lords, 5/1/24 is the separation. My lords, the allegation is that he is an impotent.
Yes.
My lords, now he is a diploma graduate. My lords, she is working as a, my lords, in a BESCOM as an engineer, my lords. She has completed as BE, my lords.
What's her salary?
My lords, she says that she is 4,500. My lords, as per the.
Trainee, Your Honor. Trainee Lordship. She's a trainee.
My lords, so even
Yes.
then, my lords, she will be getting 10,000 odd, my lords. My lords, the court has ordered for 8,000. It's an interim maintenance.
What is your income?
My lord, 37,000. My lord, she is a D group employee, my lords, in a college.
I am producing translated copy of RTCs to show that whatever the property hold by him, 12 acres of land, areca nut and coconut garden. He has utterly lied in his assets and liability statement stating that I have no property at all.
Given him a copy of it?
No, those.
Copy is produced along with this one. This is only translated for the use of the court.
Those properties are standing in the name of my mother. It's not disputed, my lord. Now
Yes.
it is a, my lords, there is no yield in this.
Is it your case that you are taking care of your mother?
My lords,
No,
I am
she-
not stated so, my lords. My lords, she is getting, my lords, rentals, my lords, for 30,000. She is having that.
She is pensioner. She is a pensioner.
But she
Compassionate job. He is owning 3 acres of land at Devanhalli Airport. Now his salary is 47,000 as per
2,000 will increase.
new pay commission.
My lords,
Another 2,000 will increase.
I'll leave to your lords.
Please come.
Honor, little bit higher.
Agreed with the word passed 9.
Nobody is dependent on him, Your Honor. He is independent.
IA number 4 in MC number 367 of 2024 dated 10th February 2025, whereby the family court had granted maintenance of an amount of rupees 8,000 per month. The wife is before this court seeking enhancement of the compensation. It is a case of the wife that the IA is filed seeking maintenance of an amount of rupees 30,000 per month and litigation expenses of 50,000. It is a case of the wife that the husband is having landed properties and also is working and earning an amount of rupees 37,000 per month. It is a case of the husband that wife is working in BESCOM, earning 10,000 per month.
Submission, Your Honor.
Huh?
He requires 35,000 per month according to assets and liability statement. He requires. Then what is the wife?
The court had granted 8,000. While granting the maintenance, the court has observed that the RTC extracts produced by the wife stands in the name of the mother-in-law. And she has also filed the photographs to show that the husband is owning houses and getting rents. And no material is placed by the husband, by her to show that the house depicts in the said photos belongs to the husband and is getting rents from those houses. Merely on the basis of the photographs, it cannot come to a conclusion that the house depicts on the photograph belongs to the husband and is getting rents from the said houses. The court has observed that the husband is working as an attender in Siddhartha Residential High School at Bapuji Nagar, Bangalore. And considering the income of 37,000, the court had granted 8,000. Then counsel appearing for the husband, the wife submits that an amount of rupees 8,000 that is awarded by the court is not a just and reasonable compensation. When the husband is earning 37,000, the court ought to have granted a reasonable amount, and with 8,000 she would not be able to eke out her livelihood, not able to manage herself. It is submitted that in BESCOM she is working as a trainee, and the amount that is paid to her is not sufficient to take care of herself. Next para, when counsel appearing to the respondent husband submits that court has rightly considered and rightly granted the maintenance. Next para, and no, there are no grounds to interfere. Next para, I heard the counsels on either side peruse the material on record. Admittedly, the husband is getting an income of 37,000. According to him, she is getting 10,000, and according to the counsel, she's earning, she's getting, she is a trainee, and she is getting a meager amount. Considering the salary of 37,000, this court deems it appropriate to grant 11,000 as maintenance. That is another 2,000 to what has already been awarded. Accordingly, the petition disposed of, enhancing the maintenance from 8,000 to
10,000.
10,000. 10,000.
Till number 28.
Machod.
Machod.
Till number 28. Revati. Adinath Narde. Vijay Tar Nayak.
Where is other side?
My lord, this is a appeal filed against the order passed by the family court.
The side is not there.
My lord, this is actually has coming for the fresh, because 2 occasions it has come, it is for compliance and one time adjournment was taken. So matter has to be heard. It is, notice has not been issued. They have filed the wakalat beforehand, my lord.
What is the interim order you're seeking?
The interim order is, my lord, the court has granted me Saturday morning to evening, Sunday morning to evening. Whereas the child is not going to school at all, my lord. So many absence from the mother's side. I have produced a document showing how negligent the mother is. She's traveling all the countries and she's putting the child at home with the grandmother and not taking. And the brothers are involved in so many crimes. I produced the FIR copies and all. This matter has to be heard because the paramount concern of this court is the child.
This matter as part heard on Monday. Yes.
It will be, my lord.
No representation on behalf of the respondent. Counsel for the petition is present. List this matter as part heard on Monday.
Publication.
Number 2. Till number 17. Pass over list number 2, CL number 17. Satisha T for appellant.
For respondent number 1.
B. Pradeep.
Yes.
Case of death, ma'am.
This is already, I think, order is taken, I number 1 of 23, to condone the delay of 37 days in filing condone. Yes.
Date of accident occurred on 29.
The table? Table.
Uniform ಮಾಡಬೇಕಾಯ್ತಲ್ವಾ ಅವರು? Page number 14, madam.
Page number 14. There is no table at
No
14.
table, madam. Only income.
Where is the synopsis?
Page number 1.
It's a case of death.
Death, madam. Bachelor death.
What is which year is the accident?
2019, madam. Criminal taken income 9 or 14,000 per month is correct, madam. Only not taking up future prospects.
What is the age?
Age is 26 years at the time of accident.
So we'll take the future prospects.
40% of the.
Yes, mister. We'll take the future prospect. Huh?
There are 2 vehicles involvement in the vehicle, madam.
In this matter, my lord, the owner is liable to pay the company.
But in the arising.
That's what he was saying, but both of you were saying something else.
No, he is appear for
The owner, my lord.
owner. Appear for the other insurance.
So in the other matter, where is that case?
My lord, that is.
I have produced.
Where is Pradeep?
DL also, my lord.
Yes, Mr. Shivanagowda. In morning, the Pradeep is directed, take notice, I've asked him to inform.
Connected.
No, in the connected MBC, the liability is fixed on the
Second respondent.
insurance company.
This case in the line.
In view of the same, respondent number 2 is liable to indemnify the respondent number 1. Shall pay the compensation with respect to the petition.
Like that.
To pay the compensation.
May make.
It may be out on Monday.
Mm.
So we will inquire whether we have satisfied the hour or prepared the appeal. Then we will accept the liability.
List this matter on Monday as part heard. Print the name of Pradeep for Cholamandala. Yes. Monday.
Cell number 19. D. Vijay Kumar.
Lord, this appeal is by the KSRTC.
Where is Mr. Rajaram S?
Raja Ramesh. Morning he was saying.
You're on what ground?
My Lord, one is negligence and quantum of compensation also.
The counsel for the KSRTC is present. No representation for the respondent claimant. This is matter as part heard on Tuesday.
Tuesday, my Lord, date, my Lord.
Yes, next.
Cell number 22.
Date, my Lord, 15th.
Tuesday, Mr. Vijay Kumar.
Will we have it on 18th or 19th, my Lord?
List on 18th.
Much honest. Much.
Yes, 22.
Cell number 22.
My lordship, this is death.
You're representing Gurudev Prasad.
Yes, yes.
Where is Jwala Kumar?
Bala Kumar.
Case of injury?
Case of death here.
Death. No, no, injury.
Death and
Liability
no
is on whom?
for insurance company.
Let's deal with it, whether they are there or not. Give it. First, common order.
Yeah.
So,
Death is
MFA 1727 is arising out of?
death case.
No, I understand, MBC.
MEC 4207 of 19.
Huh?
4207 of 19.
4207 of 19. It's a case of death.
Case of death.
Yes. Next, MFA 1118.
420.
MEC 4208 of 19.
MBC,
4208 of 19.
it's a case of?
Injury.
Then 1627.
1627 4210 of 19.
4210
of 19. Injury.
Case of?
Injury.
Yes. So first, let's take this one. MFA 1727 of 21 arising out of MBC 4207. Where is the table for 4207?
Multiplier is 60. Page number 26. Your Honor.
Table is at 24, paragraph number. What is the age of the deceased?
32.
30?
32, my lord.
What is his income according to the claimants?
9,000 they have taken.
No,
At
no.
the time, 14,000. Yeah.
No. What did they say? What is his income?
Mason. 14,000 at the time of act, 2019, the date of accident, 14,000 share.
So what I'm trying to know is, sometimes they do say that what is the income of the deceased? How much they said, that's what I asked.
Claim.
Hmm?
What's it? 1,000 rupees per day.
1,000 per day.
1,000 per day. We have taken.
Which you said, which year is the accident?
2019. Your Honor.
19, 14,000. $5,600. Court had taken how much?
9,000. Your Honor.
How much? He's a bachelor.
No, he is married.
Who are the claimants?
7 members. 9 members. 9 members. Wife, 2 wives, children, and father.
What is this two wives?
First wife and second wife, both are same as sisters, they are married.
Who is sixth respondent, sixth petitioner?
Second wife, Your Honor.
Huh?
Second wife. Both first petitioner and sixth petitioner as sisters, Your Honor.
What did the tribunal do? Tribunal considered all that.
Tribunal consider all.
Where do you get the finding?
What's your? इतना कुछ
Please come to that paragraph where the dependency is dealt with.
Para number 22, it has been said, you know. Petition number 2 and 5 and 7 are being the minor children of the petitioner. Number 6 is being the second wife. Petition number 8 and 9 are the father and mother of the deceased.
What is the multiplier?
16, my lords.
30?
32.
It comes to 30 lakhs, 10,560. Then what about the next case? It is MFA 1118.
It's an injury, Your Honor.
Where is the table?
Left forearm
In
distal
table,
radius fracture.
Table.
Where is the table?
Table, page number 34, Your Honor.
What are the injuries? Which paragraph?
29,
20?
29, my lordship. Page number 29.
Oh.
Sorry, page number 34, serial number 29.
So no, I said where the injuries are discussed.
32, page number.
Left forearm distal radial fracture. We'll give another 10,000.
Yes, sir.
40,000. Medical expenses
1,000.
as it is.
As it is.
How many days he was in hospital?
No, he has been admitted.
Hmm?
No, he has been admitted.
So court has rightly granted 1,000. What is the enhancement you're seeking in this?
For your
Next.
for MFA 1627 of 22.
MFA 1627 of 2022. Arising out of 4210.
Yes.
Where is the table?
Page number 40, serial number 38. Multiple grazed abrasion over the
1
face.
minute. So, where are injuries where are discussed? Where are the injuries discussed?
Page number 40, serial number 38. Multiple grazed abrasions over the face. Right femur segmental fracture.
40?
Page number 40.
40.
40.
Commuted mild displaced fracture of left nasal bone.
Multiple grazed abrasions, Your Honor.
Paragraph, refer to paragraph number.
Paragraph 38.
38. Multiple grazed abrasions over the face.
Right femur
Right
segmental
femur
fracture.
segmental fracture. How much amount is granted? Where is the table? Already granted enough amount. 50,000 is reasonable. Then medical expenses as it is. How many days he was in hospital?
8 days, Your Honor. 8 days, my lordship.
We'll make another 3,000.
And then income has taken 7,000. At
That
the time,
we'll see.
14,000.
Future medical expenses, what is the evidence of the doctor?
And then disability 16%.
No, future medical expenses. What did the doctor say? Spent a sum of rupees. The doctor in his chief examination affidavit deposed that the petitioner needs another surgery for removal of implant. So we'll grant another
60,000.
10,000, 30,000. Then loss of amenities, what is the disability?
16% whole body they have taken, my lordship.
What is the evidence of the doctor?
Doctor has given 16%, court has taken 12%.
12%. What is the loss of income during laid up period?
8 days. 8 days he has been admitted.
Not 8 days.
And then
Why it is not granted with the court? Loss of income during the later period. Which year is this at? 14,000 is in
No, 14,000.
into 3. It comes to 42,000. So loss of future income. $14,000 into 12. Would have taken the multiplier 16.
ಅದು minor. ನಮ್ಗೆ ಬೇಕಲ್ಲ.
I'm sorry, my lord.
Yeah. Yes, you are here.
Yes, my lord. Sorry, my lord.
So, in the first matter, that is a case of death.
Yes.
So we are taking the income at 14,000.
14,000, much.
So it is coming to 33,64,560.
Much.
Then in the second matter, no much enhancement, 10,000 for pain and suffering, 10,000 for legal expenses.
Much.
Then in this, the last one, MFA 1627, pain and suffering, no enhancement. Court has already granted 50,000. Medical expenses as it is. Transport that incidental charges, he was in hospital for 8 days. So 8,000. Court had granted 5,000.
Much.
Then future medical expenses, doctor had said 40, tribunal had granted 20, this court is granting 30. Loss of amenities, another 5,000. Then coming to the loss of income during the later period, no amount is granted. So 14,000 into 3.
Much.
42,000. Then loss of future income, 14,000 into 12 into 16. Doctor said the disability is 16%. No basis court had taken 12. So we are taking 16 instead. 16, well, so it comes to 4,30,000.
The tribunal might have taken functional disability.
No. Simply it said, but it is united. It is coming to 7,57,429 against 4,18,629. Please come. Agreed with the award passed in MVC number 4207 of 2019, MFA number 1727 of 2021 is filed. Against the award passed in MVC number 4208 of 2019, MFA 1188 of 2022. And against the award in MVC number 4210 of 2019, MFA number 1627 of 2022 is filed. The tribunal, by way of a common order, had disposed of the 3 petitions. Hence, this court is also passing a common order. First, MFA 1727 of 2021, arising out of MVC number 4207 of 2019. The tribunal has granted the compensation as per the table given below at page 24, para 24. Learned counsel appearing for the claimant submits that court had considered the income at rupees
14.
at rupees 9,000, and this accident had taken place in 2019, and the income ought to have been taken at rupees 14,000. Then counsel appearing 1,000, and it is submitted that on all counts the compensation that is awarded by the tribunal is not a just and reasonable compensation, and the compensation needs to be enhanced. Then counsel appearing for the respondent insurance company submits that the tribunal had rightly granted the compensation and there are no grounds to interfere. Next, having heard so and so. This accident had taken place in the year 2019. The notional income ought to have been taken as 14,000. If the income is taken at 14,000, considering the age of 32, future prospects at 40% will come to 5,600. That is, the income is 19,600. As there are 7 dependents, 1/5 has to be deducted towards the personal expenses. That comes to 3,920. Then the contribution to the family would be 15,680 into 12 into 16. Is the loss of dependency comes to 30,10,560. The 7 into 44 towards loss of consortium comes to 3,08,000. Funeral expenses 36,000. And in the light of the law laid down in Mekala also so and so 10,000. Altogether, the claimant is entitled for 33,64,560. Then have the table, like independently have the table. What is granted by this court? Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 23,77,200 to 33,64,560. The enhanced amount shall carry 6% interest. Then coming to MFA 1118 arising out of MBC number 42, these are all side headings, 4208 of 2019. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant. The tribunal had granted the compensation as per the table given below. Then counsel submits that when the claimant has sustained a fracture injury, court had granted only 30,000. Even under all other heads also, the amount that is awarded by the tribunal is not a just and reasonable compensation. Then counsel for the respondent insurance company submits that on all the heads, the compensation that is awarded is on the higher side. No enhancement is called for. This court has perused the award as per the table. Under the head of pain and suffering, court had granted 30,000. As he has sustained a fracture injury, this court is inclined to grant another 10,000. Then coming to and on all other counts, the court had granted reasonable compensation. No enhancement is called for. In the light of the law laid down, Mekala also so and so. No, I think this is not the case. Where is that? And no, the table is at paragraph number 29. This table is. Or the claimant is entitled for an amount of rupees 62,000. Then next, MBC number, MFA number 1627 of 2022, arising out of 4210. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant. The tribunal has awarded the compensation as per the table given below, that is at paragraph number 45. Then counsel submits that when the doctor had opined that the disability is 16%, the court without any basis had taken 12%. Further, the income is taken at 9,000. Then counsel submits that no amount is granted under the head of loss of income during the later period. And when he was in hospital for 8 days, court had granted only 5,000. Even under the future medical expenses and the loss of amenities, the amount that is awarded by the tribunal is not a reasonable compensation. When comes for the appearing for the respondent, submits that it's a just and this court the has perused the award. The under the head of pain and suffering, court had granted a reasonable amount and no interference is called for. And even under medical expenses also, basing on evidence, the court had granted. And the head of the incidental expenses, transportation, nourishment, convenience, and attendance charges, this court is granting 1,000. Coming to the future medical expenses, considering the evidence of the doctor, this court is granting 30,000. Loss of amenities, considering the not before loss of amenities, loss of income during the later period, considering that this accident has taken place in the year 2019, 14 into 3, 42,000. Coming to the loss of future income, quoted the doctor has opined that the disability is 16%. The court without any basis has taken 12%. Hence, this court is taking the disability of 16%. Then the loss of future income would be 14,000 into 12 into 16 by 100 is 4,30,080. Under the head of loss of amenities, this court is granting 25,000. In the light of the law laid down in so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 7,57,429. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 4,18,629 to 7,57,429. Yes, all the three are in this one. Yes, next.
Cell number 23.
Much.
Kahani wala.
Yes.
Step Prasad.
Yes. Huh?
Quantum as well as liability, we have questions.
Mic is on.
My appeal is for enhancement.
You said first is negligence. Let's go to that. Which paragraph?
It's evidence statement as well as the evidence of the respondent. He states that he was proceeding towards Pura, and near this Buttermilli signal, the bus had stopped at the red signal, Your Worship. And when it turned green, he moved a bit. At that time, the motorcycle rider started his motorcycle abruptly, due to which he fell down. The female rider fell down, and that is how she sustained a previous injury.
Only one.
Your Worship. And
Only one. Oh, give only one. Yes.
If Your Lordship may kindly go through this exhibit P5
No,
and P6.
both of them are going in the same direction.
They were going in the same direction.
Let's see that that discussion will go. How the court had discussed the issue. We'll read from paragraph 10.
Yes.
Please read.
Page 8 below. The last sentence.
We'll come to paragraph 13.
Paragraph?
13.
Respondent side one witness named Munirajappa, the driver of the offending vehicle, is examined as RW1 and filed the affidavit in lieu of chief examination. In his chief examination, he has repeated the entire averments of the written statement. Further produced one authorization letter marked as exhibit R1. In the cross-examination, he is admitting the accident taking place and he has not lodged any complaint against the rider of the motorcycle. With respect to the accident occurred due to the fault of the rider of the motorcycle. Further admitting that after completion of the investigation, the IO has submitted the charge sheet. So coming to exhibit P5, Your Lordship, motor vehicles accident report.
No, we'll complete reading this.
Para 15 is relevant.
Read para 15.
I've produced the spot notice and spot stage of the accident, which took place. It disclosed that the rider of the motorcycle was proceeding on Old Madras Road on the left side of the road, and the BMTC bus was also coming on the same road. When they have reached near A to B today, the driver of the bus suddenly took the same to his left side and dashed the motorcycle. Though the respondent has taken a
So it's a case of death.
No, it's
Accident.
yes.
So the injured is on the left side of the road,
left side.
and you came from back onto the next to him.
That is what we are. My case is that it never came in contact with the body of the bus, Your Worship.
No.
To that, I'm just coming with this exhibit.
No, if you go and just hit them, it makes a lot of difference to the rider of the vehicle. No injury to the no visible
No damage done to the bus, Your Worship.
no visible damages because it is not because a two-wheeler which is waiting for the signal, and when you go and hit him, nothing will happen to your bus. It is not that he came and hit you. He was already there at the signal.
He just fell, is what I'm saying. The vehicle just fell. He abruptly started the vehicle, and due to the jerk, he
Heavy vehicle, just
fell
push
in.
is sufficient.
It's sufficient. It's a small vehicle. So this is one, yes.
On the ground, Your Worship.
Then next one is,
Next is coming to the quantum.
please come to the table. Where is it?
It's the page 20 of the judgment.
So, pain and suffering. What are the injuries?
Other side is what I'm saying.
No. What are the injuries?
Fracture of right,
Fracture.
Only one fracture.
one fracture of right distal humerus with deglowing of right arm.
We will make it 50,000.
Yes, sir.
Then,
And then there was future medication and there was loss of ability to drive.
so we'll go. Let me take down all this medical expenses as it is.
As it is.
1,54,178. Then what do you say about this transportation? How many days he was in hospital?
13 days.
Huh?
13 days.
So
1 3.
another 3,000 we will add.
Yes. She is a tailor by profession.
1 minute, 13,000. Then then we'll come to the future medication. What is the evidence of the doctor?
The doctor states that the fracture has been united, Your Worship. 2 X-ray reports have been submitted. 2 X-rays have been submitted. Exhibit P, 19
Doctor says,
The implants have to be removed.
yes,
That is for the operation. So, what is the doctor's evidence?
47% to the limb and
No.
16%.
With regard to this future operation, what are the amounts
There is
required?
no estimation given, Your Worship. The evidence in the cross-examination, there is no estimation.
In your considering the age, that time, 30,000, because in all the matters, the old matters itself we are giving. Then loss of amenities, what is the disability according to the doctor?
47% to the limb and 16% to the whole body.
I think this can be reduced, amenities can be reduced to 30,000. We'll reduce it to 30,000. Coming to the loss of future income. What is the income taken?
10,000.
Which year is this?
2020, 14,500.
14,500 into 12. What is the
Into
16
15.
is taken?
15.
Into 15 into 16 by 100.
Doctor says 60,000 for future operation.
14 was taken. 14%.
Huh?
14% was taken.
On what basis?
No.
On the basis of the doctor's evidence, Your Worship. His chief examination as well as cross-examination.
17,600.
No reasons.
Then loss of income during the later period?
That will not.
Then we'll take 14,500 into 3. Coming to 43,500.
Future operation, doctor says 60,000.
Some concession should be given for this.
Yes.
coming to 7,48,278 from 5,46,178. Yes, please come. Agreed with the award passed in MVC number 2471 of 2020 dated 19th March 2021. Both the insurance company and the claimant are before this court. Insurance company's appeal is MFA number 3737 of 2021. BMTC. Both BMTC and the insurance and the claimant are before this court. And BMTC's appeal is MFA number 3737 of 2021. And the claimant's appeal is MFA number 7084 of 2021. The claim petition is filed seeking compensation of an amount of rupees 10 lakh. It is a case of the claimant that on 24/2/2020 at about 7:45 a.m. he was traveling as a pillion rider in a motorcycle, proceeding on Old Madras Road. Service road ridden by its rider carefully and cautiously. When they reached in front of A to B Hotel, Bangalore City, at that time one BMTC bus, driven by its driver in a rash and negligent manner, dashed to the petitioner's motorcycle. As a result of forced impact, he fell down and sustained grievous injuries. The tribunal had held that the accident had taken place because of the rash and negligent driving of the driver of the BMTC bus and granted the compensation as per the table given below at page number 25. Extract the table. Land counsel appearing for the BMTC submits that the motor vehicle report clearly shows that there is no visible damage to the bus, which clearly shows that as alleged there is no negligence on the part of the driver of the BMTC bus. It is submitted that, in fact, because of the negligence on the part of the rider of the vehicle, the accident has taken place, and the tribunal has failed to consider all these aspects. When it comes to the compensation, it is submitted that under the head of pain and suffering towards loss of amenities and also future medication, the amount that is awarded by the tribunal is on the higher side. The same needs to be reduced and also the shall be reduced. Next, when counsel appearing to the claimant submits that the court had failed to grant loss of income during the later period, and also when the doctor had opined that the disability is 16%, without any basis, how much it is taken? 14%. Court had taken 14%, and the income ought to have taken at 14,500, but the court had taken
10,000.
On all these counts, the amount needs to be enhanced. Next, having heard the counsels on either side, there is a material on record. First, coming to the contention of the BMTC with regard to the negligence on the part of the claimant, and particularly relying on the fact that as per the IMB report, there is no visible damage to the bus. In the considered opinion of this court, that could not be the basis for this court to come to the conclusion that there is no negligence on the negligence on the part of the driver of the bus. It is admittedly the vehicle was stopped at the signal. Later, the BMTC bus has come and hit the, according to the claimant, hit the vehicle. The police, after a full-fledged investigation, has filed the charge sheet against the driver of the BMTC bus. In the light of these circumstances, this court is of the view that the court had rightly held that the accident had taken place because of the rash and negligent driving of the rider of the bike, the rider of the BMTC bus. Hence, there are no reasons. Hence, this court finds no force in the argument of the counsel for the BMTC. Then, coming to the compensation, and the head of pain and suffering, when he has sustained what is the injury? A fracture injury and deglowing injury. The court had granted 60,000
on the right arm.
On the right, this court is granting an amount of rupees 50,000. Then medical expenses, court had rightly granted no interference is called for. Coming to the incidental expenses, he was in hospital for 13 days. Hence, this court is granting 13,000. Future medication, as per the evidence of the doctor, he requires 60,000.
60,000.
This court is granting 30,000. Loss of immunities also, considering the disability of 16%. This court is considering the disability. This court is granting 30,000. Coming to the loss of future income, the doctor has opined that the disability is 16%. On what basis court had taken 12%? 12%? 14. 12 or 14?
Court has taken 14%. Doctor said 16%.
14% is not known, considering the evidence of the doctor. This court is taken 16%. 14,500 into 12 into 15 into 16 by 100 is 4,17,600. Coming to the loss of income during the later period for 3 months, 14,500 into 3, 43,500. In the light of the law laid down in make allowance so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of 7,48,278. Accordingly, the appeal of the BMTC is dismissed, and the appeal of the claimant is partly allowed by enhancing the compensation from 5,46,178 to 7,48,278. The amount in deposit shall be forthwith transferred to the tribunal. Yes, next.
24, D. Vijay Kumar for appellant. Gurudev Prasad.
Yes. Where is Vijay Kumar?
He is outside.
Yes. Yes, you're on what ground? So there are two, this MFA 5236 is arising out of?
Same action.
No. Which MBC?
MBC called 5476 for 19.
MBC?
Going to the quantum of compensation. So last night I see how the accident has taken place.
5476 of 19 arises out of MFA 5236 of 21.
No, MFA 5236
is in respect of 5476 of 19.
5476, yes.
Yes.
Next is 5477.
Yes. And another one is 5477.
Only two.
Only two
appeals are there.
He only challenged.
Only. On what are the grounds?
Regarding negligence and quantum of compensation.
Negligence. Negligence is what?
Regarding negligence, in this accident, 4 vehicles are involved.
I think maximum number of appeals only by either KSRTC, BMTC. Only you will file. No. All this. No. About this car. In every case, negligence.
He caused a serious.
Contributory negligence.
Invariably, wherever there is no negligence at all, still they are filing against BMTC or KSR. Just become a practice. Mostly last month, my lord, it was coming in the media also.
You should see on the road.
Give the statement.
You should see on the road. You should see on the road how any BMTC or RTC bus goes. It feels that they are the only vehicle on the road.
No, that is the wrong impression.
No, it is. It might be according to you.
But they are very careful. They are strictly monitored.
You can't give them that certificate. It's not a universal.
It's the appearance itself.
Department itself is giving the certificate.
Yeah, everybody has to. They don't understand what it is.
Very appearance itself is afraid. And here he caused a series of accidents. Again he says there is no negligence.
We can about BMTC or KSRT in front of our own vehicle only.
Your BMTC.
From how they come.
Let them come, but yours is a institution. So you have to have more responsibility. So please.
We have responsibility, but we cannot avoid hitting other persons to our vehicle.
Let's see. Come to that. Which paragraph?
Page 8.
Before that, I will just explain how the accident is taken place. The accident has taken place on 30/7/2019 at about 7:30 p.m.
No, we'll read which paragraph. No, that is not in dispute. It's only on negligence, come to the relevant paragraph. Come to paragraph 9. Paragraph 9.
Let the discussion.
To understand the facts, read paragraph 9.
To prove the same, the petitioner.
23, one to dismissed. 3737.
Not exactly.
MFA 708 partly allowed. Professional leader.
And not marked as exhibit B 12 to B16. The doctor was examined at PwC and not marked exhibit B7, T2, B20. And one witness examined at PwC4 and not marked as exhibit B21. And the driver of the BMW was examined as RW1. Further, to prove the petitioner sustained due to the accident has produced copy of the FIR exhibit B1, FIR exhibit B2, which shows that the complaint in crime number so and so was lodged against the driver of the respondent vehicle. The merger along with the sketch is produced the exhibit P3 and P4, whereas it shows wherein there is shown 4 vehicles included in that the petitioner and the respondent along with the 2 cars bearing registration for KA 53 NB 3054 and car number KA 03 NB 1730 and another vehicle number KA 53 HA 7618 were involved in the accident. As per the said merger, the petitioner along with the driver of the vehicle bearing registration were injured and were admitted to Shivika Hospital. It also further states that 2 cars, 2 motorcycles and BMW buses were damaged completely. Further, the 2 cars bearing registration for KA53 NB 3754 and car number KA03 NB 1730 were moving in front, and the vehicle of the petitioner along with the vehicle number KA53 HA 7618 were following the two vehicles, which was followed by BMTC bus. The AMV report marked as exhibit P5 shows the damage to the vehicle of the petitioner at the front portion and the rear indicator damage at both sides, along with the damage at the left side petrol tank with the footrest. A final report is filed against the driver of the respondent vehicle as per exhibit P7, alleging offense principle under section 279 and 338 of IPC. As per the respondent, the alleged action was due to rational negligent driving of the petitioner in emission of 5433/19 during the cross-examination of the petitioner for PWC. It was elicited that other 4 vehicles were involved in the accident and Bolero car was moving ahead of the bus. Therefore, the issue of non-joinder of necessary party and regarding the negligence act of the said Bolero vehicle were also framed by this court on 21 and 2021 as additional issue, and additional issue was taken up and answered by this court on 27 and 2021. Further, it is further stated that in the cross-examination that the driver of the Bolero vehicle suddenly applied the brake and therefore BMTC bus dashed to the said vehicle, and that BW2 who was riding the motorcycle by the side of the Bolero lost control and came in contact with the Bolero. So there is no contact or impact between the motorcycle and the BMTC bus. It is the contact between the motorcycle of the petitioner and the Bolero.
Sketch. What is it? That is exhibit?
It is as per AMA report, my lord. Exhibit B,
He causes a series of accidents. Even then he says negligence is not.
Exhibit P5, AMA.
P5, sir.
ಈ causes ಅಂದ್ರೆ ನನ್ನ ಮೇಲೆ ಯಾಕೆ ಹೇಳ್ತೀರಾ?
ನೀವು ಅಂದ್ರೆ
I am not driving the bus.
ನೀವು ಅಂದ್ರೆ you are on behalf of.
Don't find out me.
ಈ ಅಂದ್ರೆ you are driver.
P5. All the vehicles are damaged, but the chassis is only.
Asking about the. I'm asking about the sketch, not the motor vehicle report. Exhibit? Let's see.
Bus is going on the correct side of the road, left side of the road. And motorcycle overtaking the bus. He went and dashed against the Bolero. There was no contact or impact between the
What is
Bolero.
this news story? Where from this, the submission what you're making, where from this has come?
Respondent has given evidence to the driver of the year.
Your driver will say so many things, not that alone. Let's see, let us look at let us look at the sketch. Yes.
Bus is going straight.
Hmm.
The motorcycle is coming on the left side of the bus and also passing on the left side of the Bolero. It was going ahead of the bus.
You are
The
going
Bolero
from
stopped
which,
the vehicle.
you are going from which direction to which direction?
The direction is shown.
You are going in this direction. Hmm. So where is your left side?
Left side there is a lot of space. Kindly see the sketch exhibit P4.
No, you are saying, where is the motorcycle? What is the number of the motorcycle?
Motorcycle number KA03J.
JS.
It is ahead of your car. Ahead of your bus.
Left side of the bus. It is on the left side.
I think we can understand from the sketch.
See the direction is clearly shown from a long distance. He is going straight. The bus is going straight line.
Yes.
And it is on the left side of the road.
Yes. Yes. Next.
Then my lord, regarding quantum of compensation.
Please come to that.
In my lord,
First, where is the first table?
it is on page
15. Internal page 15. So this is
kindly see the injury my lord as per
MVC number 5476.
5476, page 11.
Page 11.
page 11. She is age about 52 years. She is a staff nurse, continuing service, getting regular income.
No, it is not at page 11. It is at, I'm looking at the table. Table is at page 15. Internal page
Yes.
15.
5477.
What are the injuries, Mr. Vijay Kumar? Injuries, what are the injuries?
In page 16, fracture of left,
Huh?
left first, second, fourth, fifth, and sixth ribs.
Fracture of ribs.
Homothorax, left kidney laceration, splenic laceration, and soft tissue injuries.
The petitioner sustained right knee swelling and tenderness, partial tear of PCL, MCL complete tear, and joint, isn't it this one? 5476, paragraph number 14.
14.
It's a knee swelling, tenderness, partial tear.
Ligament tear is, the doctor also says that she needs a surgery of the ligaments repair.
50,000 is reasonable for the.
Parents only 50,000. Medical expenses and hospital charges 50,000. Food nourishment.
Just wait. I have to, just wait. We have to go step by step. How many days he was in hospital?
15 days.
37, 2019 to 14.
But there is no, you have not filed any appeal.
I have not filed.
So food and nourishment, conveyance charges,
Totally 25,000 is the one. Total.
that is on the higher side. How many days you are in hospital?
Only 14 days.
Then we'll grant on all the heads. 14,000. Yes. Next, loss of income during laid up period. Why only 4,200?
She has no loss of salary.
No, she is not continuing.
She has produced the document from the hospital authority where she is working as a staff nurse. That how many days she was absent and what was the loss of salary. That has not been produced.
Staff nurse at New Beginning Women's
They are
Clinic.
not questioning it. We'll take it as it is.
I am unable to attend for my work till still.
Loss of income during the laid up period is loss. 1 minute, loss of income during laid up period. 4,200. Then what happened to this future income?
2,700.
Huh?
3,92,700 is awarded towards loss of future income. Where there is no loss of income.
Basing on what you are saying that? Basing on what evidence?
Own evidence and document produced.
What is
She
the
has-
document?
She has not produced that she has been removed from the service.
It is
Now she has examined PW4. She says she is not coming.
What is the job she is doing?
For these injuries, she did not.
She was working as a staff nurse at New Beginning Women's Clinic and earning rupees 25,000 per month. Due to the above injuries, I am unable to attend for my work till today.
Because she has a legal.
Doctor has given only 12% disability.
Doctor says disability.
But for 12% disability, how can she resign the job and stay at home?
Yeah, at her age, 52 years, she has already
Created. There cannot be any lack of future income at all.
left kidney laceration is there, ligament tear is there. Ligament tear, she needs another surgery. That has to be corrected.
According to her, what is the income?
25,000.
Any evidence is adduced in that regard?
Evidence has not been placed.
Which year is this accident?
Salary slips are produced, 18 numbers.
But
Exhibit
nobody is
11.
examined in that regard.
No, nobody is.
Which year is the accident?
2017.
11,000. What is the multiplier?
11.
What is the disability?
Disability, doctor says 38.
Court had taken?
Court has taken 12%.
When you see para 17 of the judgment.
It's coming to 1,74,240. Yes.
Interest at 9% is that 6%. And future medical expenses are 40,000 is the word. That's also yes. They are not under any future law. Future medical expenses.
80,000, doctor says 80,000.
Interest for the word.
Repair of ligament tear.
It comes to 3,42,440 against 5,71,900. 42,440. He has come to the next table.
He is working as an
Office executive.
supervisor, office executive.
So,
He has produced the document, kindly see salary slip. How
Mr. Vijay Kumar, please come to the table. We'll go one by one.
it is at page 25, para 25.
This is MVC 5477.
Para 25.
Yes. What are the injuries?
1 lakh for fracture injuries.
Let us see what are those injuries. Where do you get that? In the order. Let's go. Don't go to the exhibits. As per the petitioner, he had sustained of left, first, second, fourth rib, empyema, hemathorax, left kidney laceration, splenic laceration, and soft tissue injuries in the left hand. Was treated with wound debridement and suturing of the left hand, thorectomy and ICD insertion.
Next page.
Medical bills are about 3,63,024.
Yes.
Para 24.
27 years. Working as office executive.
Income is not proved. Though he has produced a document that shows totally.
But 1 lakh is not high on the higher side, Mr. Gurpreet.
Which one?
The not 50,000, we'll make it 80,000.
Yeah, ribs and hemotherapy, left kidney laceration, splenic laceration, and soft tissue injuries.
80,000 will take. Yes, medical expenses.
As it is.
Food charges and attendance charges.
15 days.
How much court had granted? 25,000. Why? Not 25. 25 plus 15 plus 25.
Totally not 65,000.
So, attendant and how many days you said?
15 days.
15 days. Day 8.
15,000. Next.
The loss of amenities is open.
Amenities has to be increased.
Loss of income given the period of 10,000.
Number of injuries.
His appeal. Amenities. 15,000.
Recalculating.
Loss of income during the laid up period. 10,000 is 10,000 is granted.
Reassessing means that has to be. Your lordship is reassessing the compensation.
Basing on his
4,86,000.
4,86,000 against
5,56,000.
please come.
Interest at 6%.
Agreed with the board. Passed in MBC number 546 of 2019 and 5477 of 2019 dated
37, 2017.
37 2017. 37 2017. The BMTC is before this court. Both these MBCs are disposed of by way of a common order, and this court is also passing. Court of MBC 5476 of 2019. The claim petition is filed seeking compensation of
10 lakhs.
an amount of rupees. Seeking compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant in the accident. The tribunal has granted the compensation as per the table given below. That's at paragraph number 20. And the court had granted compensation of 5,71,900. The court when the claimant is in hospital for 14 days Court under the head of food, nourishment, conveyance, attendant charges has granted substantial amounts. Further, coming to the loss of future income, the court had granted an amount of rupees 3,92,700 without any basis. It is submitted that on all the counts, the amount that is granted by the tribunal is on the higher side. Next paragraph. And counsel appearing for the claimant submits that the court, basing on the evidence, has rightly held that the accident had taken place because of the negligence on the part of the driver of the BMTC. And coming to the compensation, a just and reasonable compensation is awarded. And no grounds or there are no grounds to interfere. Next, however, the counsel on either side, there is a material non record. This court has perused the exhibit, the motor vehicle report, the sketch, and the chart and the police records. All clearly points out at the driver of the BMTC, and the tribunal had rightly come to the conclusion that because of the negligence on the part of the driver of the BMTC bus, the accident has happened, and this court do not find any reasons to interfere. Then coming to the compensation that is awarded, and the head of pain and suffering, court had granted a reasonable amount, and also under medical expenses. Coming to the food nourishment, the amount that is granted by the court is exorbitant. This court is granting 14,000 for 14 days of hospitalization. And then coming to the loss of future income, this accident had happened in the year 2017, and the income at 11,000 into 12 into 11 into 12 by 100 is 1,74,240. And under the remaining heads, this court is not interfering. Hence, the claimant is entitled for an amount of rupees 3,42,440. Accordingly, the appeal of the BMTC is partly allowed, reducing the compensation from 5,71,900 to 3,42,440. Coming to MVC number, MFA number 5235/2021, arising out of MVC number 5477 of 2019. The tribunal has awarded the claim petition is filed, seeking compensation of how much?
5.
The next, not that is not relevant. The tribunal had granted the compensation as per the table given below.
Same.
The land counsel appearing for the claimants, the BMTC submits that when looking at the injuries, the amount of the amount that is granted at the head of pain and suffering is on the higher side. It is also submitted that when he was in hospital for 15 days, court had granted altogether an amount of 65,000 under the head of attendant charges. It is submitted that the amount needs to be reduced. Next paragraph. This court has perused injuries that are sustained by the claimant. Hence, this court deems it appropriate to grant an amount of rupees 80,000 and medical expenses of 3,66,000. No interference is called for. For the incidental expenses, considering the hospitalization of 15 days, this court is granting 15,000. And on the other counts, this court do not find any reasons to interfere. Accordingly, the appeal of the BMTC is partly allowed, reducing the compensation from 5,56,000 to 4,86,000. In both the cases, the interest is at 6% on the entire amount. Amount in deposit shall be forthwith transferred.
Bill number 25 adjourned. 26 Raghu
Take
R.
this.
26 Raghu R.
Anita. Yes. Where is the table? Para 17. Hmm. Hmm. What are the injuries? Huh? So pain and suffering will grant 50,000. Huh? What is that? 1 minute. Huh? No, first I'm saying about the pain and suffering will grant 50,000. Look at the table. No. Apart from facial injury, how many fractures? That is one. Then 70, 40, 60,000. Then medical. Hmm. What is the evidence of the doctor? Huh? No. Disability to the whole body. So what we do is towards loss of amenities, another 20,000 will grant. Hmm? And how many days he was in hospital? One minute. 3 days was in hospital. Then loss of income, no loss of income during later period. It is not about not awarded. Whether there is any loss is not there is the question. So, where is the photograph? How much? Not necessary that everybody should get married by 32. So, disfigurement how much? Disfigurement how much? 30. Huh? It's very difficult to believe. And what has clavicle fracture, what has observed, even remove that bone, it will not affect the way of his vocation. That itself is stated. When you're working, if you're huh? What is that? How many months? What? Big. Okay, 9 months. Two, 3 months will grant. Which year is this accident? 14,000. How much? 45,000. So then it comes to 2,84,950. Huh? Granted. 3,000 is there for 3 days. So 3,000 is granted. Disfigurement 30. So against 1,41,000. Please come. A week's time. Then counsel appearing to the appellant agreed with the award passed in MVC number 2752 of 2019 dated 7 January 2022. The claimant is before this court seeking enhancement of the compensation. The tribunal had granted the compensation as per the table given below. Table is at paragraph number 17. Then counsel appearing for the appellant claimant submits that the claimant had sustained. Where are the injuries? The claimant had sustained head injury with commuted fracture wall of left orbit, commuted fracture of posterior lateral wall, left maxillary sinus, commuted fracture of left zygomatic area, displaced fracture of left clavicle with left sternoclavicle joint dislocation, and lacerated wound over side face from left temple region towards a temple region. It is submitted that the tribunal had awarded only an amount of rupees 25,000 towards pain and suffering. It is submitted that no amount is granted for the loss of amenities, for the disfigurement, for the attendant and nourishment charges, and also for the loss of income during the laid up period. When counsel appearing one, it is submitted that the amount needs to be enhanced. When counsel appearing for the respondent insurance company submits that a reasonable compensation is awarded, no enhancement is called for. Next para, having heard so and so, the considering the injuries that are sustained and the head of pain and suffering, this code is granting 60,000. Medical expenses, as it is, no interference is called for. Loss of amenities, considering the disability as stated with the doctor at 12%. 10%. This code is granting 30,000. Attendant and nourishment charges for 3 days of hospitalization, 3,000. It is as it is a facial injury, considering the disfigurement, an amount of rupees 30,000 is granted. Coming to the loss of income during the later period, considering as his income is 15,000 for 3 months, 45,000. In the light of the law laid down in Makel also so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 2,84,950. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,41,950 to 2,84,950. The enhanced amount shall carry 6% interest. All will follow. Yes.
Serial number 27.
In the earlier matter, the tribunal has denied the interest on the future medical expenses. Hence, the claimant is not entitled. Yes. Inform him also. It's a good thing. Yes.
27. C.R. Ravishankar for appellant.
Yes, Mr. Shantas. He says that the TCR has to be sent, is it? Give that. Yes, it's a case of death or injury. And on what ground the insurance company is before the court? Criminal court has? On the ground? No, the acquittal by the criminal court is that it could not be proved beyond reasonable doubt. That ground we cannot. No, that's what, as far as, if it is basing on the evidence and it's not about binding nature. What I'm saying is, if the court says that basing on the evidence, it has been proved there is no negligence, that kind of a finding, we can at least look at it. When there is no evidence available or beyond reasonable doubt, then, because the standard of proof here is only preponderance of probability. Please come to that. Only, that's the only ground. Come to the quantum. Where is it? The tribunal has it fastened the contributory negligence on the claimant? You know you are arguing on that. Yes. Please come to the particular finding. We'll read the finding and understand. Please read.
The document speaks about the operating vehicle came in a rash and negligent manner in north and southern end of the BP road. Dash with motorcycle on the as a result of his fell down on his body got structured to the wheel of the offending vehicle. It dragged to the body of the deceased. If offending vehicle was driven by the in a slow manner, definitely the offending vehicle would not have stopped the definition. But after the accident, the offending vehicle dragged to the body of the deceased. Certain instances which shows offending vehicle was the driven in its driver in a rash manner. And also it is moreover, the petitioner has examined one of the evidences. Then Kresha as PwC. He is the clear leader of the moral seeker, driven by the decision. To decode the outcome, 31/3/2001 at about 1:45 p.m. Being the clear leader of the moral seeker, bearing registration number KA50K 2976 was going near Sante Circle, BP Road. My friend Jagannatha, Janarana was driving the same vehicle with carefully and cautiously appears the traffic rules and regulation at the left side of the road, and he was about to cross the Sante Circle bridge when there was a green signal for him to move. At that moment, all of a sudden, one people lorry bearing registration number KA3609 driven by its driver, in a rash and negligent manner, endangering human life, and yet helping the traffic signals, and has came in a safe speed and took sudden full left turn and hit our vehicle into the beach. In fact, Jagannatha fell down and the both sustained multiple injuries all over the body immediately.
Yes, I have seen. Yes.
And thirdly, the evidence of
Mr. Ravishekar, I have seen it. I've read the entire order. Yes. You should have examined the investigating officer. You should have examined the Your driver, your tipper driver will. Your tipper driver. No, please understand. Your tipper driver will give evidence in your favor. Why should we contain only that? Now, already PW1 has already given evidence that there is a signal. In the charge sheet, what is it rated? You have the charge sheet? No. In the charge sheet, whether they mentioned about the signal or not. In the charge sheet, whether they have mentioned about the signal or not. That's what I'm asking. Yes. Then now come to the quantum. No, you're telling it is not mentioned that. I understand that.
the difference study the BPO Bangalore because the highway. And also it takes confusion of the some extent to the
Yes, come to the quantum.
quantum relationship that's for the this one they have taken the principal prospectus and
Which year is the accident?
bachelor. The accident is the 2012.
2000?
9,000 is taken.
How much is taken?
10,000 taken, added 40%.
2012 is notional income is 8,000. Is there any evidence on record? Any evidence? Yes. Then we'll take 8,000.
For working in unorganized sector, more documents can be insisted. Only in respect of government employees, documents can be produced. Other than that, no documents can be produced. Therefore,
Yes.
he was 23 years old and 100% future prospects ought to have been taken. I mean, the council is making nice, I don't know.
Yes, yes.
Because 100%, this is 100% future prospects has to be taken. Everything is hiding on the board. Transparency and after coming into 7th pay commission and 6th pay commission, a class 4 employee is reached 3 digits.
Yes.
And moreover, the apex court categorically said, don't follow the judgment in a myopic or stereotypical manner.
Yes.
Therefore, we can't follow the judgment. It is circumstances of each case.
Yes.
You have to look into. He is a 23-year-old boy. Therefore, 100% has to be taken. And reduction of 50% is totally wrong. There is no provision under Motor Vehicles Act to deduct 50% in each and every case. Moreover, this is a loss to the family. Whatever it was earning, it has to be taken into account. And what is the logic behind reduction of the 50% in the bachelor case? What is the scientific reason it has been assigned? Here, there are 2 or 3 judges are here in High Court, bachelor judges, whether they have spent 50%. That is illogical. Therefore,
Mr. Shantaraj, I can hear you. Please don't shout. I repeatedly tell you. Please don't shout. I can't hear this loud voice. Yes.
My voice is like that.
You have to reduce it.
50% deduction and moreover, productivity, there is no provision under Motor Vehicles Act to deduct
Yes.
50%.
Yes.
And in that circumstances, whatever is earning, it has to be taken into account for loss of dependency. Moreover, transparency, there is no word used under Motor Vehicles Act.
Yes.
Only dependents are entitled for compensation. It has categorically stated that all legal representatives are entitled for compensation. Whether they have got lucrative income or not, they are entitled for compensation.
Yes.
So, an income has to be taken at 18,500. 100% future prospects. No deduction or personal expenses.
Yes. Yes. Yes, please come. Agreed with the award passed in MVC number 4666 of 2012, dated 6th August 2022. Both the insurance company, 22, both the insurance company as well as the claimant of Will you write? Accident has taken place. Compensation, the accident had taken place in the year 2012. And it is a case that he's working as an electrician and there is no evidence on record in that view of the matter. As per the table, this court is taking income at 7,000. In the future prospects at 40% will come to 2,800. That comes to 9,800. As is a bachelor, 50% has to be deducted towards the personal expenses. It comes to 4,900 into 12 into 18 is 10,58,400. Towards loss of consortium, 88,000, and funeral expenses, 36,000. In the light of the law laid down in Mekala versus so and so, 10,000 legal expenses. Altogether, the claimant is entitled for an amount of rupees 11,92,400. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 14,75,800 to 11,92,400. The amount in deposit shall be forthwith transferred to the trial court. Yes.
So number 28. 28.
Yes. Enough. We'll take up the other matters. Whatever the dates are required, please tell the court officer. Please tell the court officer. What? Huh. Which one? 40? Look at it.
Which number 3, serial number 5, RPF.
Take that file.
Yes, ma'am.
At a time I can take one case. I'll please wait. Please wait. Let me complete that. Yes. Where is the mediation report? Hmm. Hmm. What are the conditions? The petitioner pays an amount of it shall be paid in the month of November 2020 in the light of the so no amounts to be paid as of now. Huh? Huh. No. If you look at one, they have agreed to pay from September 2021 to September 2025 an amount of rupees 3,80,000, being the arrears of educational medical expenses of the respondent child. Out of the total amount, an amount of rupees 1,84,000 shall be paid by the petitioner in the month of November 2025. And the remaining balance amount shall be paid in the month of so and so. Then what has been given as of now? I think the settlement should be more clear. Now, I cannot record anything because as per the settlement, I just say, because nothing is happening today. It is all about a future successful, unsuccessful event. As per the settlement placed before this court, a memo of a joint memo is filed before this court stating that in view of the same, the petitioners do not want to, the parties do not want to pursue the matter. The parties are present before the court. Yes, next. We'll take that. What is that? Take that.
Serial number? Serial number 7.
Lord, may I have one submission, my lord?
RPFC number 20 or 25. A memo is filed stating that the disputes between the parties have amicably settled out of the court, and as per the order passed by this court, an amount of rupees 1,12,500 is deposited by the petitioner, and the respondent may be permitted to withdraw the same. The memo is taken on record in the light of the settlement. The petition is in the light of the settlement. The memo is taken on record. and the petition is permitted to withdraw the petition. And also, the respondent is at liberty to withdraw an amount of rupees 1,12,500 before this court, lying before this court. Yes, next.
Lord, serial number 1, my lords. List 3. My lords, yesterday it was not.
Date, whatever date you
Lords,
want.
wrongly it has been listed for
Serial
dismissal, my lords.
6 in the third list.
Serial number 1.
Serial number 6 in the third list. Since from
Bhagwan.
4 hearing, that is not kindly have it the first in the first list.
We'll see.
The maintenance is not paid, the petitioner counsel.
Look at all the fallout, whatever are the dates, looking at the thing, you give the dates.
Let one matter is sufficient.
Huh?
7.
List number, give that,
Please.
give this list.
Say number 7 minutes.
Lord,
In which list?
2, serial number 32.
Say number.
List number 3. 1 minute, list number 3, case number,
List number 7. Say number 3 minutes.
serial number 3. 1 minute.
6% interest.
Yes, and they'll file a joint memo tomorrow. Next is serial number 7. How much? 1 lakh. A global compensation of 1 lakh in addition to what has been awarded. 89,000 with 6% interest. And some last matter, 23? It's already, yes.
My lord, serial number 30, my lord, it's posted for judgment today, my lord.
It will come. All those matters, no, anyway, I'm not able to complete all the list. Whatever the date you want, basing on the court's this thing, she'll give the date. Please ask the court officer.
Can add it for-
ಒಂದು ನಿಮಿಷ